Hi there. I cannot hear you. Oh, hold on. That's my fault. Sorry. Your name? Hi there. Can you let me know your name? Hi. Hi. I cannot hear you. Hi. I would like to know who you are. I can't hear you. Can you? There you go.
Mary Buckley.
Mary Buckley. Okay. Thank you.
Yeah, I'm just trying to get my other one to work.
Okay, I'm going to change your name on the screen and then keep you mute till you're hearing, okay?
Yep.
Thank you.
Thanks.
Good morning, folks. We're keeping everybody muted for a while till we have a quorum of commissioners. Jill, as a commissioner, I don't mute you. You can mute yourself, but I'm not going to mute you. It's good to see you.
Good to be seen. I hope you're well.
You too.
Let's set up my view. Gonna go off screen and get my last bite of bagel.
Hi, I'm trying to get to Katie Chillis, and I'm sorry I'm pronouncing your name wrong, I'm sure. Just wanted to know what case you're here for.
Hi, I'm here for J. Edward Knight.
Okay, great. Thank you. I appreciate that.
Yep, thank you.
Commissioner Ashby, that looks super cozy. I want to be at your house. Wow.
Are you talking to me?
I am. I was just looking at the fire in the fireplace and thinking, I want to be at your house.
Yeah, I decided it was time for a fire today. It's not colder than a cold winter's day, but we're not supposed to have days like this in March. So
I know.
yeah, so it seems especially cold today.
Yeah, fake spring. Fake spring. I'll introduce Jill, who is on here, commissioners, meeting commissioners, but she's off getting a last bite of breakfast. So,
Okay, fair enough.
yeah.
Here I am.
You do not have an obligation to stay on screen.
Okay.
You're good. Good morning, Commissioner Whitworth. Hi, Commissioner David. How are you?
Good morning. How are you?
Good. How are you?
I'm
Oh, wait,
great.
did I just ask you that?
You did ask me that,
Yep.
and I'm good. I'm good.
Okay, good. Both times I asked. Good.
No change.
Okay, good.
Good morning.
Hi, Miss Williams. How you doing?
I am good. So I'm on my phone because I could use the direct link, but our computer system we think was breached, so I can't. I tried to put in the passcode and that was with the link, and it says it's wrong, 624 something. Brother, could you read it off to me just so?
I can certainly try. Hold on.
Okay.
It requires me to go to a different thing. Hold on.
Sure. I want to join with my computer because then I can see everybody.
I have it in front of me,
All
Amy.
right. Thanks, Ed.
624-2102.
2102. Okay, I think that's what I put.
That's the passcode, not the meeting ID.
Correct. 624 2102.
Correct.
Yeah, that says it's not. It says it's incorrect, but so I don't know what's going on.
Yeah, I just joined with that link. So.
Okay. All right.
Thank you, Ed.
No problem.
Hi, Amy.
Hey, Matt. How you doing?
Good, good. My first time doing one of these things, so I'm gonna,
Oh,
yeah, so if I do anything wrong, you tell me, okay?
you can be sure of it. My control issues have not changed in this venue. So for now, I'm just going to have everybody muted. Okay. Not the commissioners, but everybody else.
Okay, very good.
All right. So commissioners, it's almost time to get started. But before we do, I just want to introduce Jill Dewson, our newest commissioner, to Commissioner Ed David, Deb Whitworth, Jeff Ashby. Jeff, Deb, Ed, here's Jill. Jill, here's everybody else.
Good morning,
Welcome, Commissioner
Jill.
Newsom.
Everyone.
Morning.
Pleasure to have you here.
And Jill, you remember Barbara, our commission counsel.
I do indeed. Good morning, Barbara.
And Melody's on here, but she stays quiet and hidden, but she's on here.
She's always in the background.
Hi,
Yes.
Melody. Thank you for holding all the strings together.
She does. And then we have Joan on here too, who's also one of our office people who keeps us moving. And Alex is one of our investigators. I think that's it for MHRC people right now. Alex has almost all the cases this morning, but eventually we should have Bob and Kit as well. But until then, it will be the Alex show. So Jill, you were able to access all the stuff in the drive?
Yes, I was. And I am right now making my screen smaller and trying to open so I can have the case open at the same time.
Yeah.
On
Yeah.
the screen.
It is.
Meeting passcode ends in a 03, so I believe that the link that was shared out might be wrong.
Oh,
But 624, I think everything is the same except for the last two digits are 03. She
Okay.
said 02. Try that.
That's correct. And I'm looking at it. And of course, I didn't have to use it. I just used the hyperlink. So
Yeah.
if that's a
Hopefully-
typo, then yeah.
Yeah, I pasted it or emailed it to Joan, and it's definitely 03 in my email, but she may have used.
all right. Now we have two Rosies. Nope. Now we have one Rosie. Okay. And then I just saw, if I could just ask you folks, the newest folks, SOLME 112919, if I could just get you to tell me who you are and what case you're here for, that would be great.
I think I want to share this. Maybe that's not. Let's try this.
Those are my clients.
Those are Whose clients?
Sorry, this is Jeff Wilson. Those are the gravers on the
Okay,
Bucket Feet Graver
great.
matter.
Okay,
Steve, you can shut off your camera until it's our turn to go. I think that'd be more comfortable.
all right. Thank you. Then I think we're ready to start. Deb, I lost your little box. There you are.
Here I
Okay.
am. Okay. Good morning. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, I believe everybody does, cell phone, pager, etc., to ensure that they're silenced now. Also, if you would mute yourself, if you haven't already been muted by Amy, that would be great. You should have an agenda. You've been provided with a link to the agenda on the Maine Human Rights Commission website. We also have a consent agenda, and it's a listing of cases in which no written arguments were made to the commission in the period allotted, and we will vote on those cases. They will not be considered further today. So is there a motion to adopt the agenda and consent agenda?
So moved.
Second.
All in favor, raise your hand.
1, 2, 3, 4. Thank you.
Thank you. The minutes of February 8th. If everybody's had a chance to read them, is there a motion to approve?
So moved.
Second.
All in favor, raise your hand.
1, 2, 3. Jill, are you voting, abstaining?
Wasn't present, so I wasn't sure about voting, but I will vote, sure. They look great to me.
Barbara is shaking her head. Barbara, should she not be voting
I
in
liked
favor?
it when she was abstaining. Mark Jill as an abstention.
Okay. Well,
She just
for all
doesn't
we
know
know,
if they're accurate.
she might be opposed for all we know. So why don't we see if anyone's opposed? Jill, are you opposed or abstaining?
I am certainly not opposed. I am abstaining, please.
Okay. Thank you. Excellent.
And Amy, could we have a director's report, please?
You certainly could. Good morning, everybody, on this fine, not springy day. You have from me for administration a personnel report that notes that our Carrie has left us for greener pastures. We're trying to figure out what to do with the position at the moment. It is in the budget, which I'll talk about in new business as a part-time position. And our Jane is out on maternity leave. So you will start seeing for a few months, you will start seeing a few of Jane's cases presented by other investigators, like Alex will be doing one today. That's it for personnel. For compliance, you have a memo that is the status of reasonable grounds cases. And that shows that we have 10 cases currently in the process of being conciliated. We have 1 case that was successfully conciliated since the last meeting. And we have 3 cases that were not successful in the conciliation period since the last meeting. And I will be handling conciliations until we figure out if there's someone else that we hire or whatever to be doing that. So there is a memo. It's from Barbara, which normally they're from me, but because this one technically failed conciliation in the time period, it was actually settled right after that. It's technically from Barbara, but I'm going to go ahead and present it. It's a memo asking you to approve a settlement agreement in PA 190346, which is Demons versus Bingham General Store and Tim Earl. So it is, the agreement itself is titled conciliation agreement, just because that was drafted before when we started conciliation. So at this time, I would ask the commissioners to approve that settlement / conciliation agreement.
I'll move we approve the settlement agreement in PA 190346 A and B and the conciliation agreement.
Second. All in favor, please raise your hand.
1, 2, 3, 4. It's so nice having 4 hands. That's so nice. Okay. I will say, so the next thing in conciliation is that you have a memo about a post-conciliation case in which the parties have fully implemented all of the relief. So we're asking for the case to be dismissed, and that's in H200262. And that's Wigginton versus Moats. So I would ask that you approve the recommendation that the case be dismissed.
Move to approve the recommendation that we dismiss H20-0262.
Second.
All in favor, please raise your hand.
4-0. Excellent. Thank you. Now, I'm not sure that we managed to upload. I think we had these documents, and I'm not sure they got uploaded to you, but we do have, for investigation, we have reports about new charges, administrative dismissals, and predetermination settlements. So we had 62 new charges in February. We had 11 administrative dismissals in February. I just like to report separately about, you have a report that says administrative dismissals, but that includes right to sue requests, and I differentiate those two. And for predetermination settlements, so settlements before there was any investigator's report in the case, we had 13 of them in February with benefits of just over $365,000 to complainants. The next thing we would report on during this part of the director's report, we usually would talk about litigation and ask about that to be discussed after executive session, because there are things that we need to talk about in pending or anticipated litigation in executive session before you vote. So I would ask that we defer discussion of litigation until after executive session, which leads us to new business. And you have a new folder in your business folder, a subfolder for budget stuff, because this is the time at the legislature when we are doing the biennial budget. And also, so there's the current year's supplemental budget, the second year, the short year that the state looks to wrap up any pending issues and make the accounts balance. We've presented to the legislature on that. I believe I gave you copies of our testimony in February for that. So what you have in this folder now is the testimony that we have provided about the 2-year biennial budget that is coming up. So 21, 22, 22, 23. So we started the process for making this biennial budget started last summer when the pandemic was only getting started, and we did not know that it would be this long standing. So what was in the governor's budget for us, it was good in that there weren't a ton of cuts, but our needs have changed since the time that that budget was drafted. So the initial testimony that we gave to the legislature on March 1, and you all have a copy of that, basically just talked about what was in the governor's budget, which was continuing a half a position cut that was from the curtailment, and an internal reorganization that we did to sort of get rid of internal middle management stuff to save money and not lose positions, and to try to effectuate reclassifications for our investigators, which has been a long-standing issue, as some of you may recall. And there were 2 different things that were clumped together. One was a management-initiated reclassification, and one was a sort of parallel employee-initiated reclassification that we owe interest on because those are retroactive. So our initial testimony addressed those things. And it was after that that we realized, number one, the March 3rd testimony was answering some questions that a legislator had about our all other monies, which is, what are they and where do they come from and what do we use them for? So that was answering those questions and correcting one thing that I got wrong, which was really, I think, me typing it wrong. But that's the point at which Melody and I realized that we couldn't just go along with this budget and not tell the legislature what our actual needs were, because the vast majority of our budget goes towards personnel, and you can't use we move things around using approved financial orders and things like that all the time, but you can't use personnel services money for anything else. And really our greatest need right now, because it's been a year. And at this point, we think about 90% of our work is happening online, electronic submissions, which is huge considering that a year ago, we didn't accept electronic filings at all. And so in a year, we've gone to 90% doing everything online. We're adopting as we go, creating as we go an electronic data management system. And our number one, we need more tech support. Melody is doing all the tech support, which is pretty much 24/7 because there's all of us and one of her. And what she has said, and she says it all the time, but I think I don't listen as much as perhaps I should, which is if she can't address something immediately for one of us or even one of you commissioners, whenever you need something, there's a work stoppage. And that's a union issue that we can't be in the way of that. And Mel actually cannot work 24/7, even though I think she's been doing it for a while. I know, who could have thought, but that's what she's been doing in addition to doing our budget stuff and our website and our physical plant and paying our bills and doing our hiring and pretty much everything else that nobody else does. Mel's doing it. And so we submitted on March 3rd. You have a little document that looks like this. This was our plea, our last minute plea to the legislature to say, look, we need to change up our priorities and we're going to tell you how we're going to do it. So we were telling the legislature our biggest need is to get to be able to contract and use some of the money that was saved on our behalf through the curtailment to support our staff with tech support. And we want the state to pay more of the cost of the management initiated reclassification for investigators. Then you have a document that looks like this, which was our providing to the legislature the documents that they need that look how they expect to show how we were going to do it. And so we met with Judiciary. We were there all day waiting for them on, it might have been Tuesday, it might have been Monday, I don't remember. And they didn't get to us. So we showed up another day and they got to us and they approved our request, which was to basically use the money that we saved by losing half a position and cutting out internal middle management and put it towards tech support. And they also approved our request to reclassify the investigators with a little more support from the state and to get the employee initiated reclassification paid. We found out after that hearing that we actually had been given the wrong number for the employee initiated reclassification. So we are trying to deal with that with the Bureau of the Budget and DAFs so that they can pay it. We don't have the money. We said, you gave us this information, we presented it, it got approved. So we're going to work that out with them. We will not be paying the cost of that, I can promise you that. So that is the ongoing saga of the budget. However, all those things were the easy part. Now it goes to appropriations and they haven't seen our revised numbers. And we're going to be duking it out with every other agency for all their line items. And getting them to understand the change in what we're requesting, because we're basically, what Judiciary approved was taking out what the governor had proposed and replacing it with what we proposed. It costs the state an additional $5,000 a year, what we proposed. I think it's 5, it might be 7. So it's a minimal cost, but it's something new. And we're going to have to explain why that is and how it happened and why it should be approved. So that's the budget. I know you're probably gonna have questions about that. I would say sit on it, ponder it. If you want to ask me right now, I'm happy to answer it. But I just gave you a lot of information and it might help to just sort of take it in a little bit. You also have, unrelated to the budget, you have copies of other things we've submitted, like our annually required quasi-independent report. All quasi-independent agencies have to submit a report about expenditures and donations that we've made on behalf of members of the commission or our staff. We did that like we do every year. And you also have a copy of our long-awaited annual report, which is great reading, riveting. It is not riveting. I find it riveting. And whenever anybody says they've read it, I automatically like them more. But I will tell you this, if you take nothing else away from it, and even if you don't read it, I'll tell you this, our case filings were up 8% in the last fiscal year, and our backlog is up 10%. So, and we had a lot of turnover. So that's the short version of the annual report. And I'm happy to answer questions about any of those, either now or later.
I just want to say, I know Melody was very involved in putting the annual report together, and probably some of the other staff. The annual report, even though people may not think it's great reading, it is extraordinary reading. And I urge everybody to read it cover to cover. The statistics are interesting. The narrative is interesting. It's really good information, and it gives us a snapshot into the business and the housing environment in the state of Maine. So thank you for all your good and very hard work, everybody who was involved.
Excellent. That's all I have for new business.
Amy, I
yes.
was wondering how that recent it was the paralegal that left. Is that going to play? Are they going to try to snatch that back and not let us fill that for budget constraint, or don't they know about that?
They don't know about that, and we don't expect
never mind.
Yeah, we don't expect it to be vacant very long. We have every intention of filling it quickly, or if we don't fill that position, turning it into some other position. I don't know, but we'll be filling it super quick. So Deb, do you want to go on to the cases? Oh, you're muted. Still muted. There you go.
Thank you. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Sorry, I got to get my agenda. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions, and I will ask that you introduce yourself as you are called to present. So our first case today is E19-0103, Mary Yakabaskets. I'm sorry that I did that to your last name. The J. Edward Knight and Company. Is there anybody here for Ms. Yakabakis?
Yes. Hi, Commissioner. I'm Kristen Aiello here for Mary Yakabaskis.
You have 10 minutes.
Okay, thank you. I'd like to reserve 2 minutes, please.
Sure.
Good morning, Commissioners, Attorney Tarasevich, parties. My name is Kristen Aiello. I'm here on behalf of Mary Yakabaskis. I'm here to highlight some of the issues raised in the investigator's report. We strongly believe that the investigator erred in recommending that there are no reasonable grounds and erred in applying the reasonable grounds standard. As you know, the reasonable grounds standard in these cases is at least an even chance of complainant prevailing in a civil action. And more specifically, at least an even chance of complainant proving in court that unlawful discrimination occurred. I want to emphasize to the commissioners, certainly this is, there's a lot of material that you have in front of you, both the investigator's report and our concerns with the report, but I will highlight some of those things here today. I want to first say that the respondent made illegal disability inquiries and harassed complainant based on her disability, to the point that she was on the verge of tears and had to ask the supervisor to stop because she didn't want to cry in front of him. Despite her 20 years of experience in the insurance industry, excellent work history, 3.5 years of positive work for respondent, pay raises and bonuses, as well as respondent's acknowledgement throughout that she was a good employee. Unfortunately and surprisingly, everything changed after she returned from leave. Respondent retaliated against her and then terminated Mary within 11 days of her complaint of disability-based harassment and within seconds of her assertion of her rights under the ADA, when the owner stated, "Don't tell me about the law, pack your bags, you're fired." And I've highlighted in here, there's a dispute between the parties regarding what was said, but I did highlight the post-termination emails that were sent back and forth that really do underscore that Mary has been unwavering in her position, and it has not been specifically denied, certainly not in the email responses that you have in front of you. So just you have the facts in front of you. I'd like to just start on our first reason that we believe that you should overturn the investigator's report, and that is that the respondent absolutely made impermissible disability-related inquiries that were not permissible under the Maine Human Rights Act and the ADA. As you know, the general rule is that the law prohibits an employer from making inquiries as to whether an individual is a person with a disability or as to the nature or severity of the disability, unless it falls under an exception. An employer may seek this information if they have a reasonable belief based on objective evidence that an employee will be unable to perform the essential functions of her job because of a medical condition. The investigator erred in mischaracterizing this exception for the rule as relevant to an employee's work. What isn't relevant to an employee's work? This prohibition that's been set by Congress and the Maine legislature is really important. It does allow an employer to reasonably inquire if there is objective evidence, but it doesn't allow for what happened in this case. Here, the situation is clear that when a supervisor goes into an employee's office and starts grilling that employee on their aid for their disability, in this case, hearing aids, that's not a permissible type inquiry. There is no question that this occurred, that the supervisor went into Mary's office, started asking her about why she couldn't turn up the hearing aids, was clearly irritated at her, very concerned. This has been an ongoing thing when he speaks to her outside her office. He continued aggressively pressing her about why she couldn't turn up the volume on her hearing aids. The supervisor never alleged that there was an issue with her hearing clients. The supervisor told Mary she needed to get new hearing aids. She told him that she wasn't able to do that, but her hearing aids work fine. She doesn't have a problem with hearing her clients. The supervisor just continued to relentlessly demand why Mary couldn't turn up the volume. Imagine if this were a situation with someone who uses medication for a mental disability, for example. The investigator's position is that that supervisor could come in and start asking that employee, what is your medication working? Shouldn't you increase your medication? Shouldn't you get new medication? This is absolutely not permissible. And the investigator clearly erred in barely analyzing this line of questioning and erred in finding that there were no reasonable grounds on this. In addition, going hand in hand, you have the facts in front of you. We believe the investigator erred in failing to find that respondent harassed complainant based on her disability. Unwelcome comments and any other verbal or physical conduct related to physical disability constitutes harassment on the basis of disability when such conduct has the purpose or effect of substantially interfering with an individual's work performance. Mary has met this standard in this case. This behavior of a supervisor going into an office and pressing and relentlessly demanding to know about hearing aids in this case is absolutely impermissible, both as an inquiry and also in terms of altering an employee's workplace and employee's experience. It was objectively and subjectively offensive behavior. And a reasonable person certainly would find it so. Let's see. Even supposing for a minute that the investigator's characterization of the interaction is correct, which it is not, and that the supervisor was within his right to discuss the functionality of complainant's hearing aids, supervisor was aggressive and clearly not acting in good faith. The respondent could produce no objective evidence of job performance issues because of complainant's medical condition, which would in any way, shape, or form justify this questioning. Hearing aids are personal devices, not accommodations that the complainant was seeking from respondent. Respondent is not required to provide personal devices at work, and complainant was not seeking that. And respondent made repeated impermissible inquiries about complainant's disability. In addition, the investigator erred in failing to find that respondent retaliated against complainant and interfered with her rights in violation of the law and the Whistleblowers Protection Act, including the Whistleblowers Protection Act, and unlawfully terminated her. In this case, the evidence shows that after January 5th, when she was subjected to that questioning, she had a sleepless night. She was incredibly stressed out. She was unable to focus at work. At about 4:30 in the morning, she had emailed HR director and indicated that she was going to have to take a personal day because she was harassed because of her hearing. The response—
That's 8 minutes.
Okay, thank you. The response was simply, we don't believe that you were harassed. We conduct an investigation, and sorry, we're not taking any action on it. Nothing was done. She was never asked about the harassment. Later, when she was asked to come to the meeting, by the way, the supervisors last spoke with her on January 3rd, didn't speak to her again until her termination on January 14th. At which point the evidence establishes that during a meeting, when she raised her ADA rights, she was told by a very angry owner with a raised voice to pack her bags. Don't lecture me about the law. And in fact, this is admitted by the owner that he said, don't lecture me about the law. And she was told she was terminated. I'll reserve the rest of my time for rebuttal. Thank you.
Questions for Ms. Aiello from commissioners? Commissioner Whitworth, where'd you go? There you are. None at this time? Okay. Commissioner Ashby.
Yeah, just a couple. Council, do you think there's an element of constructive termination here in the event that we adopt our investigators' findings about that meeting where she's told to calm down or pack her bags and leave? Do you have concerns about the reasonableness of the way that was portrayed to her, if that hypothetical is true?
I do. I think that a constructive discharge would be applicable if the commission were to find that the conditions were so intolerable that no reasonable person could be expected to be in that workplace or continue. So yes, if the commissioners made that finding, I think that a constructive discharge could be an appropriate recommendation in this case.
I mean, I think the case kind of, at least from the investigator's point of view, hinges on that exchange, and I'm not sure well, I don't know how I feel about the findings yet. We haven't heard the other side, but I'm concerned about the representation that she should, if she can't calm down, she should pack her bags and leave. She'd been there, what, 3.5 years? Is that right?
She had been there 3.5 years, right?
Never disciplined before this?
Never disciplined before this.
Okay, thank you.
Commissioner David? Oh, you're muted. There you go.
Yeah, you've described the situation as ongoing and severe and pervasive. As I'm reading these facts, it's primarily the one conversation where the supervisor's interrogating her about turning up the volume. Isn't that correct?
Yes, that is correct, Commissioner. But I would point out, as the investigator has cited, the Rainbow Rugs, I think it is, case, the law court has held that one incident of harassment can be enough if it's sufficiently severe. And we would certainly advocate and point out that, yes, we believe that this was sufficiently severe to have a supervisor come into a small office and interrogate an employee with a disability about her personal device for her disability repeatedly and relentlessly. That would be enough to meet the standard of harassment.
And the investigator cites talking to witnesses about that conversation, particularly about whether or not she quit. Isn't there a witness that's involved there?
There are three people in that meeting: the HR manager, the owner, and my client. I think what the investigator might be referring to are the two other people who work in the office, supervisor and coworker. The owner says that my client was screaming, quote unquote, for 15 minutes. The HR manager said that the meeting went on for 5 minutes total. The outside coworker, the supervisor said he, quote, didn't hear anything outside that door. So this is a small office where one of the witnesses says he didn't hear anything. The other witness says that she heard something and she went into the office where supervisor was. So I guess the other point that I make with regard to, quote, witnesses is, at one point, I believe the investigator characterizes coworker as an unbiased or independent witness. And I would disagree that a coworker, someone who works under owner, HR manager, and supervisor, is an independent witness.
Is there corroboration for how long the supervisor was in her office asking her about the hearing aids? What period of time that is?
Commissioner, that's a good question. I don't recall off the top of my head what the time period of his being in there was. It was enough time as detailed in the facts to go through all the line of questioning that he made of her.
Thank you.
Thank you.
Commissioner Dewson, any questions for you? If you're still, there you go.
I'll offer this correction early on. My name is Dewson, and not Dewson, but just thank you very much. I'm wondering, I want to make sure I haven't missed something. The only two present in the room when it happened were the supervisor and the complainant. I've not missed a third party who was in the room and witness to the actual conversation.
The only two people, it's my understanding, in the room, you're right, Commissioner, it were my client and the supervisor. The coworker was present in the office, but not in the room.
And could not hear what was being said.
I don't recall the testimony on what that individual heard outside the door.
Okay, thank you.
Or if they heard,
I
yeah.
think I saw on the record that She said she couldn't hear what was going on. But,
Okay.
it was just some testimony about the tone, whether there were voices raised or not, but no one else heard the substance of the conversation contemporaneously. Thank you. I just wanted to be sure I hadn't missed something.
Thank you, Commissioner.
Okay, so at this point, we will move on to, hold on, I'm just sending someone else the password. We got a lot of password issues. Hold on. We will move on and Ms. Aiello, you will have a minute left when we come back to you. We're going to move over to Mr. Tarasevich, who I'm sure I've mispronounced everybody's names, so equal opportunity offender here.
That's okay. It wouldn't be the first time. My name is Matt Tarasevich, and I represent Jaywood Knight. Jaywood is a small mid-coast insurance company at which complainant used to work. With me here, their screens are off, is the owner of the company, Rob Wheeler, and the HR director, Katie Childs. I think they're observing this today. Interestingly enough, obviously we support the investigator's well-reasoned and well-researched report. In this case, she interviewed all the witnesses. And what is an interesting thing here, and I think a couple of the commissioners touched upon it in their questioning of Attorney Aiello, is in her objection to the report, she doesn't mention the coworker who was there. She doesn't mention her at all. And there are two events here which really are the kind of the seminal events which form this claim. And that is an interaction that happened on January 4, 2019. And the coworker was right there. She heard that. She was interviewed. And in the report, the investigator finds, based upon what everybody's observations of that, and that this wasn't something that was being grilled or objectively offensive or being harassed, that she doesn't make those findings, because what actually happened was that the complainant was complaining about her hearing aids. She was hired by the company as somebody with a disability. Yet now they claim that 3.5 years, 4 years later, they harassed her because of a disability. That makes no sense. She was complaining to her coworker about her hearing aids, and the supervisor joined in the conversation, tried to offer helpful things like, could you try this? Could you try that? It wasn't a grilling. It wasn't an interrogation. It wasn't any of those things. It was simply an offer to help a coworker who was complaining about something. And, we all know about the interactive process, but this seems to be an interesting claim where if somebody with a disability complains about their disability and is overheard by a supervisor, then if they try and engage in something, just try and help when trying to engage in an interactive process, now that's discrimination. So it's damned if you do and damned if you don't if you're an employer. If somebody complains about something, you try and help, then you're in trouble. So, and everybody was interviewed here by the investigator, and the version of what happened on January 4th was supported by the coworker. And the investigator finds that in the report, and the attorney for the complainant ignores that in her opposition, completely ignores it. There was a second event here. There was a pre-scheduled January 14th meeting between every quarter the company, the owner and the HR director meets with the employees. They go around, meet with the employees and do like a check-in. It's non-disciplinary, and they're going to speak about things. And during that meeting, complainant immediately began screaming and yelling at both of them. And again, ignored in the opposition objection by the complainant is the fact that the coworker was sitting right outside the door, a couple of feet outside that door. And the supervisor was seated away, 2 offices away in his office. The screaming by complainant was so bad that the coworker got up and went to the office to get away from it. That was the testimony the investigator heard. And so for a complainant to say that she's having some calm conversation, she's being discriminated, she went into a meeting that was non-disciplinary, a quarterly check-in meeting, and acted in a manner that no employer would tolerate. If you worked at the Human Rights Commission, you would not tolerate that type of behavior. If you worked at the Disability Rights Center, you would not tolerate that type of behavior. If you worked in my office, it wouldn't be tolerated. And in this case, her behavior was so egregious and outrageous that eventually the owner said, either stop or you can leave. And she did. She got up out of the office, the testimony, she walked out, she began slamming doors. She went to her office, grabbed her stuff and walked out the building. If she hadn't have done that, she'd still be working there. Because by all accounts, she was a good employee. But she, for whatever reason, she decided to take things up about 18 notches and make a case out of something that wasn't there. There's also a complaint here that somehow she was retaliated. There was no retaliation here. She took a couple of FMLA leaves. The evidence shows every time she asked for a leave, she was granted it. She was getting extended leaves. The complaint of harassment, she agreed that when they met on the 14th, they would talk about that. But the company, the HR director, had already looked into that and talked to the other employees and found that there was nothing there. It was simply a conversation about her complaints about her hearing aids. That's not harassment. That's not grilling. That's not interrogation. This is a case where complainant in her complaint lengthy goes on to numerous allegations. And then she repeats them in her opposition to the position statement. Then she repeats them again in her objection to the report by the investigator. But the conclusions are the same. The company did nothing wrong here. It had an employee who, for whatever reason, decided to take things to another level. And again, she would still be working there today if she had not conducted herself and decided to walk out. She was not fired. She quit. I'll reserve the rest of my time or certainly answer any questions.
Okay, hold on one second. Questions for Mr. I've already forgotten how to pronounce it. Tarasevich. Tarasevich. I apologize to everyone today. Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby.
My unmute button wasn't working. Just a couple. So you certainly agree, or do you agree, that she had made the complaint after that meeting with the supervisor, that she wrote in and said, look, this thing happened. I can't come to work the next day. I feel like I've been harassed. That happened, correct?
That did happen. And that I believe by agreement, they were going to discuss it on the 14th.
All right. So the complainant agreed, she agreed to sort of put off any discussion of it until later, or I understand the complainant to be saying the response was that I got an email back without any investigation, at least as to me. No one spoke to me, but I got an email back saying I wasn't harassed.
There are two facts here you have to understand. First of all, the company did, and HR did speak to everybody else. They had already heard, and what they heard was this was a mountain out of a molehill. This was a conversation about her complaining about her hearing aids and them trying to deal with it. And she is turning a mountain out of a molehill. And so that's part of what they had heard, including from the co-employee who was there, who disagrees with her characterization of what happened. And secondly, they had a meeting scheduled on the 14th. And they had, and this came out through the testimony of the investigator, that she had a problematic issue with another employee a couple of years ago where she just went kind of wild and was screaming at people. And they wanted to wait until the 14th to kind of calm this thing down and give it a little space. And it was only a few days. And I don't think there's any allegation of any other harassment or anything else between the 4th and the 14th.
I don't want to sound like I'm arguing with you, but so the only other person though that was a witness to that conversation was the supervisor, and he's the person who advised HR that she was making a mountain out of a molehill, right? I mean, my understanding the facts.
That's incorrect, Commissioner. The other employee as well said that. There was another employee there who, in her initial conversation, was with the co-employee, and then the supervisor overheard that conversation. This is a very small office. I mean, incredibly small office. And he heard the conversation and he started interacting with them, just offering suggestions. So it wasn't just the supervisor saying a mountain out of a molehill. The co-employee heard the whole thing and she was interviewed by the investigator. And as I said, complainant in her opposition just ignores that conversation took place. You don't have the luxury, but apparently she thinks she does.
And so moving on to the second seminal event, as you referred to it, the issue of the meeting on the 14th, that as I understand well, you've characterized her behavior as intolerable. You repeated that a number of times and said that if behavior occurred anywhere else in other places of employment, it'd be intolerable. Are you suggesting that she was terminated for that behavior, meaning she behaved so badly that it was appropriate to get rid of her? Or are you like how relevant is the intolerability of her behavior that day if she wasn't actually terminated?
She wasn't terminated. She decided to leave. And they simply wanted her behavior to stop. She wasn't, again, nobody's saying that she wasn't a good employee. And as I said, she would still be working there today. But you cannot go in, I maintain you cannot go into a meeting with your supervisor, your bosses, and scream and yell at them. I don't think it could happen to any of the commissioners here that that type of behavior would be countenanced. Here, they gave an opportunity. He goes, leave. You can leave or stop. Just stop. She got up and walked out of the room.
And the investigators report at page 5. Do you have that with you? Do you have it in front of you?
Yes.
Paragraph 2 at the top of page 5 is the investigators' findings regarding that meeting. And I understand at the end of that paragraph that this exchange took place, that it was said that she should calm down or leave, meaning that complainant could calm down or quit. CSR, that's the witness outside the office, as I understand it, and the supervisor both recalled owner coming then to say complainant is done. There's no finding there about what the complainant said or did when she was told she could calm down or leave. Is there anything in the record that helps us understand what the complainant did at that moment other than storm out and grab her things? Did she say, fine, I'm ending my employment with you folks?
She just got up. My understanding is she just got up and left. I remember, began slamming doors and went and emptied out her office and left. So she made a choice. She could stay or she could leave. And she made the choice to leave.
And that's when the owner went out and told everybody complainant is done.
Yeah.
Okay, thank you so much.
Commissioner Dusan. Oh, I'm sorry, I skipped Commissioner David. I apologize. We generally go in order of seniority. Apologies to Commissioner David.
Oh, Matt, what's the agenda for the meeting on the 14th with the owner?
There typically isn't an agenda. These are quarterly meetings. They're scheduled like 3 months ahead. They're on the calendar, and it's a check-in. What can we do for you? What do you need? How are things going? It's a very loosey-goosey type of meeting that scheduled all the employees. And that day, the other employees who were in the office also met and had the same type of meeting. So there's no real agenda here, but certainly the employer that day was prepared to talk to her about what had happened on the 4th. And in their view, they felt like, let's nothing had happened and let's put this behind us. Let's move on. And that wasn't her agenda. Her agenda was to start yelling and at them, and they were absolutely taken aback by her behavior.
The owner is interviewed by the investigator. Is that correct?
Yes.
And the witnesses?
Yes, all of them, including the witness who's not mentioned in the complainant's objections.
That's all.
Okay, Commissioner Dusan.
Yeah, what I can't tell from the record, and please correct me if it's inappropriate for me to ask these questions. I'm curious to know if for these quarterly meetings, was it general practice to go into the office with the employee? In other words, in the record or in the comments and in your comments, Mr. T.
Mr. T works.
There's a lot made out of the employee who sat right outside of that office, being so disturbed that she got up and went away from the area. I'm curious to know if it was standard practice, if that employee had been the one doing the quarterly review. I want to be corrected if I'm surmising that in a general HR situation for the quarterly review, you wouldn't do it in that outer office where everyone is so closely together. You would go in the office. Is that correct?
Before you answer, Mr. Tarasevich, again, I'm just going to go with Mr. T because I'm going to say it wrong every possible way. The investigator is shaking her head as though the question you were just asking, that information was not in the record.
Okay, all right.
No, I'm sorry. I might have been gesticulating. It was in the record.
Oh.
If you want, I can answer that question.
Well, if it's in the record, then let's let the question to Mr. T continue.
Okay, J. Edward Knight has 3 different offices. So when they do these quarterly meetings, they do have it in a private office, and the employee and the owner, HR director, and the employees come in and meet with them, have an informal meeting. There's no real agenda, but they come in and the door is closed. It just happened. This office, this is the Booth Bay office. That one, with the employee. The coworker was seated. Her station was right outside that door. She was right there.
Thank you. The other thing I want to make sure I'm understanding from the record is that there are a couple instances where there are discussions, the 2 instances where there are discussions with the complainant about her hearing aids, one before the quarterly meeting, and one during the quarterly meeting. But the one before the quarterly meeting, do I understand that both the respondent supervisor and the HR manager concluded that the conversation that sparked this was I think what I'm seeing specifically in record is that one person saw it as a minor issue, and the other felt that the complainant had been fully resolved. How was that communicated? Can you remind me how that was communicated to the complainant? I think it was a later email, but I want to make sure I'm understanding.
2 things. I think you're right. There was a that meeting on the 4th. Actually, what happened on the 4th was initially a conversation between the coworker and the complainant based upon complaints she was making about her hearing aids, in which the supervisor joined. She later, I think the next day, sent an email complaining of harassment. Yeah, and in response to that, I believe there's an email in the record where HR emailed her in response to that. And so that was partial of the response. And the other part was the intent to meet with her on the 14th to have a further discussion at the quarterly meeting. But I believe there's an email, a letter or an email dated the 5th, maybe, in response to her email on the 4th. I might have the day off by one.
Well, I made that note to myself, and I was just posing the question out loud as part of the record to make sure I had not misunderstood. So I think it was clearly outlined by Ms. Brindley, but I wanted to make sure I did not misunderstand. Because the energy with which the complainant came into the meeting is basically the matter of dispute here. The other part of my question is, so help me not conclude. No, I don't want to say that. Never mind. I think I'm fine. Thank you.
Okay. All right, so we're going to turn back to Ms. Aiello, who has 1 minute.
Okay. Thank you. I cannot disagree more with regard to the way this meeting has been described by respondent. It certainly is an excellent defense that an employee is going wild in a meeting and yelling and screaming, and that's inappropriate behavior. If that was happening, I wouldn't be here. The fact is that the respondent's position in this has been rife with inconsistencies. In his notes after this meeting, owner never said anything about my client screaming during the meeting. This is something, exaggerations have been clearly documented in this case. For example, the owner says that my client was screaming for 15 minutes. the other HR says that this meeting lasted about 5 minutes. And it also, if it's true that my client's behavior was so outrageous and obnoxious and terrible as described by counsel, then why wasn't that even mentioned during the email exchange post-termination? In those email exchanges, yes.
I'm sorry to interrupt you, but that is your time.
Okay, thank you.
Questions for Ms. Aiello, Commissioner Whitworth,
No, no questions.
Commissioner Ashby,
No, thank you.
Commissioner David?
No.
Commissioner Duzon? No. Okay. Thank you, Ms. Aiello. Mr. Tarasevich? Again, yeah, sorry. I'm just gonna say Matt. You have about 4.5 minutes.
I don't need 4.5 minutes. I just want to address one thing, and that was just raised about why weren't there's things I think in her post resignation, emails. I think they're in the record. She sent a couple very aggressive emails characterizing herself as having been fired, which my client responded, "No, you weren't." And then it seems to be used to be held against them. And then I think there was some argument at some point that then my client stopped responding to them, those emails, and that somehow shows some sort of ill intent or ill behavior by them. I can tell you at that point they had retained counsel because of the nature of the threats, the false threats that were coming against them. Like any wise employer, who saw employees making false claims against them, making threats, you call your lawyer. And that's where the correspondence stopped. So, and I don't think that can be held against any respondent. And other than that, I can answer any other questions.
Thank you. Commissioner Whitworth?
No questions.
Commissioner Ashby?
No, thank you, Council.
Commissioner David?
No.
Commissioner Duzon?
No, thank you.
Okay, thank you. All right, now we turn to our investigator who is presenting a report that actually Jane O'Reilly did the investigation and Alex is presenting it.
Yes, I wish I could say I wrote this report because it was well done, but alas, I was not the investigator on this case. I am just taking over for Jane in the interim during her leave. As such, if you have any questions, I'm available to answer any of them. I'm very familiar with the case. I spent the last week or so reading and reviewing all the documents, all the recordings, so just let me know. And Barbara also can answer any questions that I might not be able to answer.
And I know that Alex did talk with Jane at the time that the investigation was being done as well.
Yes, extensively.
So questions for the investigator, Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
Just one. I want to pick up where I left off in my earlier questioning. The findings regarding that meeting, that meeting on the 14th, really do sort of leave still a little unclear what the complainant said upon, if she said anything at all, what she actually communicated upon the suggestion that she needed to either calm down or leave.
So based on the recordings of interviews that Investigator O'Reilly conducted, it doesn't seem to me that the complainant said anything in response to whatever the respondent owner said, just stood up and left, banged around some stuff and grabbed her stuff and left. I don't believe she said anything saying I quit or anything like that, but I believe that's what happened.
Okay, thank you.
Mm-hmm.
Commissioner David?
Is there any other incidents that's alleged by complainant to be unlawful discrimination based on her hearing disability, other than the supervisor talking to her in that one time?
No, just the January 4th meeting, or conversation rather.
And her disability is known at the time of her hiring?
I believe it was.
Okay, thank you.
Commissioner Duzon?
And were there For me, forgive me for asking so many questions. It's my first meeting, my first review of all these records. And I just want to make sure I'm proceeding appropriately. My concerns are centered around the nature of the complainant's disability and the trying to find information in the record as to how the respondent's management of the complainant's accommodation was handled. I read in the file that there was discussion on the respondent side about prior complaints about the complainant, interactions with one or two customers, and the concern in those matters was the volume of the complainant's voice, but that these items were not communicated to the complainant.
That is correct.
And these items, if they were about volume, might have a reasonable connection with a conversation about her disability.
With questions about the hearing aids, yes.
Yeah. Okay, thank you.
Mhm.
Okay, any other questions from commissioners for the investigator? Seeing none, thank you, Alex. So at this point, we've heard from the parties, we've heard from the investigator, and typically at this point, we would have a motion or motions and any discussion. And I believe there are, there's 2 proposed findings, which could be taken separately or together.
Well, I'll move to take them together. I think the retaliation follows from the first issue, and I'll move that there are no reasonable grounds to believe that they discriminated unlawfully on the basis of disability.
Is there a second?
Second.
It's been moved and seconded. Is there any discussion?
Yeah, Commissioner.
Go ahead, Joe.
Oh, sorry. Well, I'll let you speak in support of your motion.
Well, yeah, I made the motion. It is a mountain out of the molehill, and I am I think somehow it escalated by the complainant. I don't see that the history suggests that there was severe and pervasive harassment. That supervisor, complainant says he overstepped his bounds and continued to ask her too much about, well, why don't you get new hearing aids or turn them up or whatever. But that does not seem to constitute in the context of having hired her with that known disability. It seems credible that she's complaining about the hearing aids herself. I have hearing aids. I complain about them to coworkers. That there was that conversation. It may have been a little bit over the top, but it's not severe and pervasive discrimination based on her disability. And from there it goes downhill, and that's not the respondent's fault.
So I'm going to vote against your motion, Commissioner David, but respectfully, and it's a good investigator's report. I don't have any anxiety about the report itself. I just think the even shot standard, together with the temporal proximity to what I think was an artlessly handled, I don't know if we get to constructive termination. I think that the circumstances regarding her departure make whether or not she was terminated very unclear, so unclear that it's an even shot question for me. I don't think it's a hostile environment case as much as it's a discharge case. And I do think there's at least an even shot of her retaliation claim as well. No one disputes that the discussion about hearing aids occurred. No one disputes that upset the complainant. No one disputes that she asked for a meeting about it. And no one seems to dispute that she really wasn't, nobody investigated her side of that exchange before they told her she hadn't been harassed. And so it's understandable then that on the 14th, she came into a meeting quite concerned that her rights weren't being taken care of. And she indicated as much and said the ADA protects me. And I don't think anyone disputes that she was told, don't lecture us about the ADA, calm down or get out. And she didn't say anything and then left. And that's, you know, the end of a person's employment after 3.5 years is such a big deal. The owner ought to, at that moment, have taken some further steps to clarify that maybe a little calming down and cooling off would be appropriate before she depart the way she did. I think there's an even shot in this case under all those facts.
Any other discussion? While I have the mic, I would just, hold on one second. I know Barbara was about to offer this up, but I would just remind commissioners for a brief second that the standard for unlawful environment is severe or pervasive, not severe and pervasive. Severe or pervasive, not severe and pervasive. Sorry, Commissioner Doosan, you were about to speak up.
Yes, I have a question to you or Commission Counsel. Could you tell me the terms of art for what Commissioner Ashby has described as even shot?
Yeah,
I
do that. Forgive
describe
me,
it,
Commissioner.
I describe it as tie goes to the runner.
Okay, and our finding of discrimination having likely occurred is tied to our concluding that the complainant would not have a even shot at prevailing if she went forward with this matter.
Yeah, if complainant has an even, essentially 50% or better, then.
Okay. All right. So is this the point at which I offer comments regarding which way I am leaning?
If you choose to, or you don't have to. You could surprise us all.
I shock you. Ooh. I'm okay with proceeding with that then. I will be, with all respect to my fellow commissioners and the mover and seconder, understanding that we have to get a motion on the record for people to, oh, I'm done, Barbara. I don't have another question. Understanding that we don't.
That's never stopped me from saying things, Jill. So.
Okay. I saw you leaning forward as though you were expecting me to, but you were just leaning forward to hear me. Thank you. Understanding we have to get a motion on the record in order to make a decision, and I appreciate and respect those steps. I am leaning to vote no on the motion, and the reason for that is in the end, when I went back and forth over the reports and findings, and it was, yes, a very excellent report. I think it comes down to an issue of credibility between the parties as to who said what in that room. And those present dispute that. And I believe that this complainant, if she went forward, would have more than 50% opportunity to prevail on her description of what happened, or what was said and her response to it. And there are a couple of things that fall from that for me. One is the statement of calm down or leave, paraphrasing, of course, can be read by the complainant as, if I can't calm down, I need to leave the room. She did not say I quit. No one alleges that she says I quit. So she accepted the invitation to calm down or leave and left. That doesn't, now I don't think there's enough in the record to substantiate that her intent at that time was to leave forever. And she disputes that she intended to quit in later interactions. The respondent side of this, of what the respondent meant by calm down or leave, that they interpreted her leaving as resignation. But the only thing actually said as to that conclusion contemporaneously is coming out of the office and saying to other staff, she's done. And even that is what that meant is subject to interpretation. So I think the complainant has a more than 50% chance of prevailing on this if it comes down to what was said in the room and who meant what by what they said. The other pieces that concern me in the record, which I think would be worked out in the party's presentation in court, should they go that far, is this, what I gather from the record of the mountain out of a molehill concerns me. And the pattern that I see behind that is minimizing the disability from the perception of the complainant. And the only way I can get to that is by looking at behavior that's in the record. I can't tell what's in either party's head, but I do read in the record that this was a discussion about a disability that the complainant does not have the opportunity to change. A remedy for that disability or modification for the impact of that disability in the workplace proposed by the respondent, who says, turn up your hearing aids. And it's just the discussion in the email record that respondent felt that complainant's discussion about her disability in a non-private space, the first conversation, wasn't important. Wasn't something that there was an HR responsibility to respond to specifically in relation to communications with the complainant. It can be, I just think that there's enough gray area here in terms of response to the disability and how the disability is to be accommodated in the workplace and how that accommodation might be adjusted by either party in the face of specific issues, behavior. There's enough gray here that the complainant might prevail. So I will be voting no on the motion.
So the current motion is to find no reasonable grounds on both the proposed findings. And if this, just so folks know, as Commissioner Dusan noted, if this motion does not prevail, someone else can make another motion. Is there any other discussion on the current motion? All those in favor of a finding of no reasonable grounds for disability discrimination and retaliation, raise your hand. All those commissioners. So this is no reasonable grounds. No reasonable grounds. Okay, so I have two commissioners, David and Whitworth, are in favor. All those commissioners opposed to a no reasonable grounds finding. 2-2. So the commission's standard is if there's a tie vote, it defaults to no reasonable grounds. So at this point, if someone else wants to make another motion, you can, or you can let this one stand because presumably the motion for a no reasonable grounds likely will end up the same unless someone convinces someone else.
May I ask, just remind me, if a follow-up motion is made for reasonable grounds and the vote is the same, what is the default outcome is that there's no reasonable grounds?
Correct. If there's not a majority vote in favor of reasonable grounds.
And what impact does that have on the complainant's ability to move forward?
When we dismiss the case, the complainant will be able to go to court within 90 days of our decision.
Okay, thank you. A lot of my questions are about reminding myself of all the steps. So I won't be asking you this in my third meeting.
So the initial finding is no reasonable grounds. Does anybody want to make an additional motion?
I just don't see the efficacy of doing so in light of the tie vote. I don't anticipate it changing. Otherwise, I would have made a motion for reasonable grounds.
So without any additional motion, the finding on both claims is no reasonable grounds, and the commission will send the parties a letter. I love the discussion. I will just remind commissioners that we are now an hour in and we've heard one case. So this is my routine reminder for the benefit of the folks who are waiting, that we try to keep ourselves to the, I don't even know what words I would say there. To be brisk, that's what I'll say. Brisk but thorough. Commissioner Ashby might be crying right now. I'm not sure. All right. Deb, you want to call the next case?
So our next case, E19-0240AB, Deborah Lawrence v. Wise Business Forms. Is there anybody here for Deborah Lawrence?
Ms. Lawrence is here. I just saw, oh, there she is. Okay. And Ms. Lawrence, do you have audio on a phone? Because right now you're muted. Nope, you're muted.
Unmuted.
There you go.
There you go.
So you have 10 minutes. Okay. Well, good morning to the commissioners. I never planned to ever have to proceed with any claims and whatnot, but I was wrongfully fired due to the fact that I apparently disobeyed a direct order. And I was also told that I did not do what I was told. I was asked to write an order that I had never written before. I had questions. When I asked the questions, my manager got extremely volatile by slamming his fingertips on the order that was in front of me. He was extremely agitated as he came into the area where the CSRs were. And his demeanor was that he could not see my screen. I wanted to tell him that the order that was to be written was saying that it wasn't a repeat order, and that's a red flag. So I was trying to ask him the question, and he just got angry and told me to write the order and proceed, and that if I didn't write the order, I could just go home. Well, while he was getting angry, he was banging his fingers on my desk, and his body was slamming it against me. I couldn't get out of my desk because he was standing over me. And so I got up and I went to my general manager and told him that what had occurred. And I said, I'd like to go home, but I don't really want to go home because I had a lot of work, and what work I don't get done today is going to compound to the next day. And he said, no, he just shook his head and said, I need to go talk to the manager. And he goes, just give me a call in the morning. And because I told him, he said, don't come in tomorrow or Friday. And I said, well, so what do I do? So I called him in the morning. He said to come in. He told me that my manager would be meeting with me. And I went into the meeting, said good morning. And he said, this is just an oral meeting to discuss what happened yesterday. And next thing I know, he's sliding this form across to me that was the disciplinarian form. Didn't have anything other than what I had stated previously, that I didn't obey a direct order, and that was incorrect, and that I didn't do what I was told, because I had already started the order. I actually offered to write the order, but I had a question. So I said, he asked me to sign the form, and I said, well, I can't sign this form because you're saying I disobeyed an order when I actually started the order, and I started to input it. And he said, well, you didn't do what you were told. And I said, I did do what I was told. And so I looked at him and I said, so if I don't sign this form, I'm fired. And he said, yes. So I immediately just said, well, thank you. I said, and got up and went to the general manager because I knew I wasn't going to get any further with it. The general manager was out in the production area. He was standing next to another worker there, and I said, you told me I wasn't going to be fired. This is the third time you told me I wasn't going to be fired. Because I'd asked him before I went into the meeting, am I going to be fired? And he said no. So the other coworker, who was Barry, also heard the discussion.
Ms. Lawrence, could you speak up a little bit? It's kind of hard to hear you. There's a lot of feedback.
Okay, sure. So the manager, the same manager is a manager who has always been extremely vulgar. The same manager choked me on an occasion that I was at work. This manager has called me an idiot. He's called me stupid. He's always making comments about my clothing. He's talked about us all being older people and that the general manager wanted to hire younger people. And he's asked me to forge a sales agreement to sell his wife's car so that he could sell it to an employee at Wise. I've gone on vacation and come back, and I went into his office to ask him if he had anything he wanted to say to me while I was gone. Is there anything I needed to know about? Because I had the most, I'm sorry, I'm nervous. Most important client that we have at Wise, and I supported that client, our largest account, I should say. He asked me if I had a good vacation and then looked at me and said, "You're beautiful." That was totally unwanted. I have a disability that I wrote in the file that on occasions I can't get to work right on time. It's usually a few minutes late, and I'm not happy about that. I'm kind of embarrassed by it, but my disability prevents me. I need a bathroom. So to not go into details on that, I had a note for Wise, but the general manager refused it. He said he didn't want to know anything about it. He was angry about it, and I'm a good employee. I don't know why I had to be put through this whole situation when I am a good employee. The account that I handled, when I told them that I was no longer with Wise, he was very saddened by that. He said that he depended on me and that was a big deal to him, and that he appreciated all the work that I did for him and his employees. I, was out in production one day and I slipped and fell because there was chipboard floor, and I didn't see it, and I slipped and fell. Had to go to Concentra, and the general manager didn't make it an easy process. I have never had a workman's comp. I've worked for a company that's very large for 30 years and only had accolades and exceeded expectations, and was told that how can you be so patient? Well, I was patient, but after this occurred, my patience wore through, and that's why I faced this claim. So there's other things that I put in my report. I don't know if the report was written, so I won't go into detail, but I'd like to reserve anything. Oh, and I will also say one last thing is that the manager makes comments such as, and I'm going to warn you, this is not nice, and I don't even really want it to come out of my mouth, but I walked into his office on 2 different occasions. One occasion was he was getting off the phone and he makes a lewd comment that says, that guy is a cocksucker. And on another occasion, when I walked into his office while he's getting off the phone, he says, that guy is such a penis. Well, in the world that I came from after 30 years, that was not allowed. Any sexual comments or vulgar comments was never allowed. So this is why I have placed my complaint with the Maine Human Rights Commission. And I thank you for listening to me today.
Thank you. Questions at this point for, well, hold on, I'm just writing the time, for Ms. Lawrence. Commissioner Whitworth,
No questions, thank you.
Commissioner Ashby,
None, thank you.
Commissioner David,
The disciplinary form that he asked you to sign, you say, as I understand it, that you refused because you thought it was an admission by you to the conduct. Is that correct?
Right. I felt that if I signed the form for what he put for 2 statements, it was an untrue, it was a false statement that was not true. So it would be an admission of not doing what I was told when I had already started the order.
And I'm unclear, Ms. Lawrence, you made a reference to you've never had a workers' comp claim. Exactly what discrimination, unlawful discrimination, is it that you allege here? Is it the work environment? I mean, you referred to inappropriate language. How has this difference about the order to write the order that caused all this an indication of unlawful discrimination?
Well, I think that because I wanted to write the order, I think that it's an accumulative information that I just presented, that because of my medical disability, it didn't set well with the general manager. And I feel that all of this accumulation that I gave to you was to just get rid of me. And I feel that that they discriminated against me because of my medical condition.
Okay, so you're focusing on the disability as what you're alleging as the discriminatory intent.
The disability, the reason for that I got hurt. Both times the general manager was extremely upset about the fact that I got hurt. And I don't know if it's because it reflects back on him or what it was, but the whole situation just seemed like it was accumulative to firing me.
And I'm sorry, I don't recall in the report an indication of you getting hurt. What was that incident?
I was bringing some plates, big metal plates, out to the production area, and I was holding them by my hands like this, and they're big plates. And when I went to go and put the plates down on the table, I slipped. And when I got up, I saw this chipboard. So the chipboard had toppled over. I didn't see it, and I got hurt. So I had to go to Concentra, and I had sprained my neck and
when was that, Ms. Lawrence?
That was in April.
Okay.
April of 2018, I'm sorry.
April of 2018?
Yes.
Okay, thank you. That's all.
I just want to clarify, the issue with the workers' compensation claim is that it's not the type of workers' compensation discrimination that we cover. We cover discrimination based on workers' comp claims against a prior employer. So if an employer finds out that the complainant had filed comp claims in prior work and discriminates based on that. Discrimination based on the by the employer against whom the workers' comp claim was filed is covered by the workers' compensation statutes and the workers' comp board.
Yes, thank you. Thank you, Barbara.
Thank you.
Commissioner David, any other questions for Ms. Lawrence?
No, thank you.
Okay, Commissioner Dusan, any questions?
I think I should hold it for the staff person, for the investigator.
Okay. All right, Ms. Lawrence, you'll have a little bit over a minute left when we come back to you. I'm going to mute you for now.
Thank you.
And then we turn Ms. Williams, I believe.
Yes, good morning, Commissioners. Attorney Rosie Williams on behalf of Wise Business Forums. In preparing for today, I wanted to just remind the argument or frame the argument around the proper framework in which we're looking at today's submissions. The case has been very well briefed, and today's discussion is supposed to focus not on any new factual development, but rather whether there were any items to be pointed out as part of the investigator's report that were improper from the record. It's not an opportunity to develop new facts or to make new legal arguments. This case has been pending for many months at this point. And the letter that was submitted on behalf of the complainant did not raise any additional concerns with the specific concerns with the report, or were there any indications that the legal framework in which the report was based were inappropriate. Obviously, Wise Business Forums is in support of the investigator's findings, both from a legal framework and from a factual framework. As investigator Brindley pointed out, the claim is untimely based on the statute. And that's the important first step in evaluating whether there are any reasonable grounds for discrimination. If there's been no factual development contrary to the investigator's findings or pointed out by the complainant herself. Second of all, even if that we were to set aside that legal framework in which to analyze this case, the factual development does not rise under the McDonnell-Douglas burden shifting analysis to a finding of any discrimination. There has been a number of grievances that have been aired, but those grievances do not rise to the level of any discriminatory conduct. And as I said, the factual record has been developed through the pleadings, and any new factual development or any new facts mentioned here today are not open for consideration. Addressing Commissioner David's question to the complainant about if there's interest with regards to the meeting following the insubordination, the complainant was given the opportunity to make any corrections on the form, and she declined that opportunity. She's told she was allowed to write anything she wanted on the reverse side of the complaint, the write-up, and she chose not to do that. That's the most important fact here to highlight from the record. But as I mentioned, this is not an opportunity to develop a new record. The record has been well vetted in front of the investigator, and the decision is supported by her analysis. unless there's any other questions from the commissioner, I would ask that the board adopt the recommendation of the investigator that there are no reasonable grounds for discrimination.
Thank you. Questions for Ms. Williams? Commissioner Whitworth?
No questions.
Commissioner Ashby?
None, thank you.
Commissioner David?
Was that disciplinary form part of the record? Was it submitted?
Yes.
Thank you. That's all.
Commissioner Dusan?
Yes, this question I thought I should say for the investigator, but I think Ms. Williams has a just as close a knowledge of it. The disciplinary form, is there an official section on the form where one can insert the response? As I've seen many standard disciplinary forms, or was this reference to the ability to write comments on the back a contemporaneous offer?
That was a contemporaneous offer, as far as I understand, that she was to take the time that she needed to make any correction that was necessary if she disagreed with what was written, and that would be an acceptable outcome from the meeting.
But there's not an empty box on the form headed.
No, it's my
employee
understanding.
comments.
No, the complainant had the opportunity to write everything on the reverse of the form, the whole page.
Any other questions, Ms. Dusan? Are you all set?
No, I'm all set.
Okay. Thank you, Ms. Williams. You'll have time after we go back to Ms. Lawrence. Ms. Lawrence, you have about a little over a minute. If you want to use it, you don't have to, but you are welcome to. Oh, hold on. Let me unmute you. Hold on. Oh, actually, I can't unmute you. I can ask you to unmute. Thank you.
Yes. The form does not have any area on it to sign, and I had actually said that. I said, you don't even have anything here for me to dispute this. I think that the fact that the way he was speaking to me, I just got really upset, and I didn't want to be upset. So I just said, well, if I'm going to be fired for not signing this form, then I just said thank you and walked out and went to the general manager, because he had already told me that I wasn't going to be fired. So I don't know why he was fired. He told me that he would even, the day prior, that when I went home, he said that I would be paid for the rest of the day. So I just thought that, okay, well, I'm going to go talk to him and the general manager will fix this, because he said that I wasn't going to be fired. And
Ms. Lawrence, that's your time.
That's fine. Thank you.
Any follow-up questions for Ms. Lawrence? Commissioner Whitworth?
No questions. Thank you.
Commissioner Ashby?
No, thank you.
Commissioner David?
Did he tell you that you could respond to the form?
He looked at the supervisor that was there from the production area and said, get her a piece of paper. And then I said, well, if I can make comments on the back. And he said, I don't even know what he said. I said I could make comments. I don't even think he said anything.
But somebody said, get her a piece of paper. I mean, you talked about your ability to make comments, right?
Right.
Thank you.
Commissioner Dusan, any questions?
None, thank you.
Okay, thank you, Ms. Lawrence. Now we'll go back to Ms. Williams. Ms. Williams, you have about 6 minutes left. If you want to use them, you don't have to. Oh, you're muted.
Thank you, commissioners. I don't have anything further to add. Like I said, we would ask that the commission accept the report of the investigator.
Any follow-up questions for Ms. Williams? Commissioner Whitworth? Nope. Commissioner Ashby? Nope. Commissioner David? Nope. Commissioner Dusan? Nope. Okay. Thank you, Ms. Williams. Now we've heard from the parties and we would turn back to investigator Alex Brindley, who is muted. Thank you.
Yes, I was muted. I am not now. My name's still Alex Brinley. I was the investigator to this case. I don't really have anything else to add. Like Ms. Williams said, this complaint was actually untimely. It was pointed out to me after the fact by Commission Counsel. So in cases such as this, an AD likely would have been written because it was untimely, but considering I had already written the report and done the investigation, we just left the report as is. So if anyone has any questions, I'm open to them.
Commissioner Whitworth? Questions for Ms. Brinley? No. Commissioner Ashby?
None, thank you.
Commissioner David?
Do we have that form that she was asked to sign, the disciplinary form?
Yeah, do you want to see it?
No, I just wonder, is her description, is Ms. Lawrence's description of somebody saying, get her a piece of paper and basically offering her the ability to respond accurate?
I believe she was given the ability to make edits and respond. However, there was no, dropping all of my papers, there was no area on the form itself for edits.
I got it. Question for Barbara, who's
She's still there. She's still there.
Is it timely or not, Barbara? I mean, do we have the discretion to waive the day and to consider it on the merits or not?
Oh, we can't hear you, Ed. Sorry, Ed, we couldn't hear you for a second there.
The question for Barbara is it untimely and therefore dismissed, or do we have the authority to waive the day and hear it on the merits, as it were?
Well, intriguingly, you do not have the authority. I mean, there was never any request. We can accept late complaints for good cause shown. There was never any request. There was never anything that happened. What happened is we believed there was an intake form which would have made this timely, but it turned out that was not the case. And since Alex had already worked so hard in investigating this case, we decided to issue the report so that complainant would have an explanation of what happened. To suddenly get an AD saying that her complaint was untimely, given everything that had happened, just seemed like it wouldn't give, we thought it was worth giving her the explanation of what would have happened on her claims. But in reality, no, there's been no request to extend, and an untimely claim would normally have been dismissed as no reasonable grounds.
Commissioner Duzon,
long-windedly.
Commissioner Duzon, questions for the investigator or Barbara?
Because I'm the newbie, but okay, my only area that I want to make sure I understand is that in the matter of this, well, first of all, let me say that I really appreciate the staff's administrative decisions to err on the side of people being heard and letting the work that Ms. Brinley had already done and letting the matter come to the commission. This complaint, which is untimely, Ms. Brindler, did not include any equally untimely claims about choking, name calling, comments on clothing, forgery, profane references, or references to appearance. The only two items that were listed by Ms. Lawrence that were referenced in the complaint are one relating to sex, and the other was the workers' comp claim on which we had no jurisdiction. Did I miss something?
No, I think that's mostly accurate. So her original complaint, she alleged age discrimination and sex discrimination only in her original complaint. She later amended her complaint to add the whistleblowers, the workers' compensation. That's the one.
Okay, so there's not this cumulative information in support of her claim in the record or in her discussions with our staff during the investigation.
I don't believe so, no.
Thank you.
Commissioner Duzon, is that any other questions?
I'm all done, thank you.
Okay. All right, so commissioners, you've heard from the parties and from the investigators. So at this point, typically we would have a motion. There is one proposed finding.
I'll move to find that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of age, sex, and/or disability, or retaliated against her for filing a previous workers' compensation claim, and that the complaint should be dismissed in accordance with the Act.
Second.
So it's been moved and seconded. All those commissioners in favor of a no reasonable grounds finding on all of the claims that.
You need to ask us for discussion, don't you?
Oh my gosh, I'm so sorry. Thank you. Thank you, Commissioner David. I apologize. See, it's a good thing someone's paying attention. The motion is for no reasonable grounds, a finding of no reasonable grounds on all of the claims presented by Ms. Lawrence. Is there any discussion?
No.
No, I just didn't want to be silenced in case I came up with something.
Completely appreciate that. I don't want to silence anyone.
I think
Until
it's
time to silence you. Yeah.
I think it's been fully aired in the discussion on both sides.
Okay, any other discussion from commissioners? Seeing none. All those commissioners in favor of a finding of no reasonable grounds to believe that Ms. Lawrence was subjected to unlawful discrimination or retaliation, raise your hand and say yes.
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 1, 2, 3, 4. So the finding is 4-0 in favor of a no reasonable grounds finding, and the commission will send both parties and attorney for respondent will send you a letter outlining or confirming this finding and letting you know the process that you can follow from here. And we thank you, and we will move on to the next case. I think there are folks here for the next case.
Yeah.
You want to call
So
that done?
Our next case, E19-0241AB, Lana Smith, the Custom Coach and Limousine, and Paul Graves Mitchell, Hope Simons. Is there anybody here for Lana Smith?
I thought I saw somebody who was on the phone before. The name of their phone looked like it was Lana Smith. I messaged them to ask if that was them, and I didn't get an answer. They don't seem to be on the phone now. They don't seem to be on the call now. I don't see them in either a phone call or the video that was on before. So I don't know if there's anybody else here who's on the call for Ms. Smith. Is there anyone here for Ms. Smith? I see you, Ms. McCormick. I know you're here for respondent. Yeah. My only concern is if somehow Ms. Smith was on and had trouble with tech, but I don't know what to do about that.
We could move on to the next case and try calling it again at the very end.
Yes, I would suggest we do that. Okay. So moving on to the next case on advice of Commission Counsel. E19-0333-5AB, Sean Sweeney, the UPS Freight and Teamsters Local number 340. Is there anybody here for Sean Sweeney?
Yes.
Okay. You have 10 minutes.
Thank you. Good morning, commissioners. My name is Brett Baber, and I represent the complainant, Sean Sweeney. Mr. Sweeney had been employed since 1993 and still employed by the respondent, UPS. Starting in the late 90s, Mr. Sweeney, because of his ADHD, he has attention deficit hyperactivity disorder, has asked for and provided support, medical support for reasonable accommodations for his disability in the form of being assigned to a specific job. And my objection that I filed is really very narrowly focused. We don't need to get into the record in extraordinary detail, unlike the other cases. The problem with the investigator's report in this instance is that the investigator completely overlooked, not completely overlooked, she actually provided some factual support for his reasonable accommodations claim, but then she dismissed the core complaint in this case, which is a reasonable accommodation claim, in a very brief footnote. And she indicates that the only matter at issue in the case is whether complainant's most recent discharge was because of his disability. The investigator simply failed to analyze Mr. Sweeney's reasonable accommodations claim, which, if you read his complaint, was really the crux of his complaint. He alleges that this was a continuing action going back to July of 2017, with the most recent discrimination occurring before his most recent termination. And just so everybody is on the same page, he was actually reinstated following a union grievance after that termination. He alleged in his complaint that he was given as an accommodation and actually consistent with his union contract, a position as a small sort package handler. But at various points in time, that UPS would take him out of that position and require him to serve as a floater, which is counterindicated by his doctors for his attention deficit hyperactivity disorder. And I'll basically leave it there. As the commission knows, it is a discrete form of discrimination under the definition of discrimination within the Maine Human Rights Act for not making reasonable accommodations. If you look under the definition of discriminate, there's case law I'd be happy to cite that makes it very clear that a reasonable accommodations claim is a discrete claim. The investigator should have gone further than dismissing his reasonable accommodations claim in a footnote, done the analysis, and if that analysis had been undertaken, we submit that there are more than ample grounds for a finding that there is a reasonable basis for a finding of discrimination based on failure to accommodate. I'll reserve the rest of my time.
Thank you, Mr. Baber. Questions for Mr. Baber, Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
Yes, hello, Council. So it is a little unclear in the investigator's report what exactly happened with the accommodation request. First of all, you're referencing the accommodation request made in 2006. Is that correct?
Actually, Commissioner, that accommodation in and of itself would be untimely, but what happened, that's part of the record going back many, many years. The accommodation was granted. UPS said, yes, we will put you into this pre-sort position going back to 2006. But right up to the present, from time to time, they would pull him off his position as a pre-sorter into a float, wherever we need you position, which is not recognizing his accommodation. So yes, it started in 2006, but continues all the way until this most recent event in 2019.
So just to put a sort of a finer point on it, though, the accommodation request made in 2006, where there seems to be evidence in the record that this request for him to be not subject to the same repeating, or to be subject to the same repeating tasks, was granted, but then ultimately the employer departed from that practice, and that's what is that the denial of accommodation, the departure from an accommodation that had been made years ago?
Exactly.
There isn't a new accommodation request made. It's a continuing, sort of implied, continued request for accommodation that intermittently is the employer fails to continue to honor.
Yeah, his disability never went away. He's always had attention deficit hyperactivity disorder, and he, again, consistent with his union rights, the accommodation was to allow him to work in this one specific position as a pre-sorter, and it is the repeated act by the employer to insist that he do something outside of that that is the denial of his accommodation request.
So it's a failure to accommodate more than it's a denial of accommodation from your perspective?
I think they're, you know, two.
Not a denial of a specific request for accommodation. It's
correct. It's not like he came and said, I need to be able to take a 2-hour break to get my, you know, mental faculties under control, and then they denied that. But it's the employer's request not to observe the granted accommodation that is the discrimination that's occurring.
Okay, so thank you. That helps me understand what your concern is about the investigator's report. I just have a question about on page 2 of the report, then the footnote, which the footnote 5, which I think you referenced in your statements. I don't understand the statement that the request was denied based on inadequate documentation. I understood footnote 5 to referring to the 2006 request for accommodation, and in fact, it had been granted. So can you help me understand the footnote?
I frankly don't understand the footnote. The footnote, the request was actually honored. They gave him the pre-sort position. And then, you know, this would have been a good case if the investigator had engaged in some dialogue in person with myself and Mr. Sweeney. He provided the documents that the investigator requested, but there really wasn't any opportunity to clarify, although I think he made it really clear in his complaint that it was moving him out of the pre-sort position into the floater position on a random ad hoc basis. That was the basis of his accommodations.
Okay, thank you. Well, we have the investigator here, so thank you. We'll be able to inquire further. Thanks so much.
Commissioner David, any questions for Mr. Baber?
Yes, it seems to me that the crux of the investigator's findings are in the second to the last long paragraph before the recommendations, and she's saying there that the incident was unconnected to the disability stressors, that his disability diagnosis and difficulties with attention, inconsistency, and managing frustration. And then she says that this incident is provoked by his view of some other employees' behavior and results in unacceptable behavior on the complainant's part. Is that not? Are you questioning those factual findings?
I will question those factual findings in a different forum. For now, I think the investigator has gone beyond the reasonable accommodations question. She's looking at the unlawful termination, which I think those factual findings are pertinent. We disagree with those, but they're pertinent to the unlawful termination. But where the failure to accommodate claim comes in was the request by the employer, ab initio, to move him out of his pre-sort position to work as a floater that day. That in and of itself is a failure to accommodate, and the investigator doesn't go any further to analyze that. That's the inherent flaw in this report.
And you're saying that that's that day?
Yes.
Right. That's all.
Commissioner Dusan, and questions for Mr. Baber?
Have questions. I'm not sure who to direct them to. But no, I don't believe it's Mr. Baber, so thank you very much. Well, one, your understanding of the reasonable accommodation process that your client participated in, is this accommodation something, so the accommodation was first in 19-something and 1993, and then it's in 2006 that we have discussion of a accommodation requested and denied. Was this accommodation reviewed on some kind of regular cycle? Is this on some annual basis, or at what point would a complainant renew the request for accommodation, as in your understanding of the process?
I believe it's in the record, but he actually brought a previous complaint back at the time. I think it was known as a charge of discrimination before the Human Rights Commission in the 2012-2014 timeframe. This was an ongoing dialogue between Mr. Sweeney and UPS. In fact, he had been terminated, quote unquote, 25 times by UPS over the years. He would object to those terminations through his union representation, saying, I was assigned to pre-sort as an accommodation. You folks didn't honor that. And then he would be reinstated, much like he was in this case. Although in this case, it was more a question of what was the appropriate discipline. So yes, there was an ongoing record of dialogue between the employer and Mr. Sweeney regarding his accommodation, which was very simple: honor his union rights, assign him to the pre-sort.
And those incidents are triggered by, for the most part, by the employer making an assignment different than the specific position, assigning him to a floater position. And then, so the regular process, apparently, in the case, is that he would have this accommodation, be assigned to the regular position, and then occasionally the employer would reassign him to a floater. He would complain and remind of the accommodation, and they would proceed to work it out.
That's correct.
Okay, thank you.
Thank you, Commissioner.
Okay, so we will now turn, Mr. Baber, you'll have just over 6 minutes when we come back to you. We're going to turn to, I believe it's Mr. Silver.
Good morning, Commissioners. I'm Steve Silver on behalf of UPS, and there's really two issues, but I'll start with what we focused on, which is the accommodation issue. There was never an accommodation granted, ever, until 2020. It just happened in November of 2020, okay? The investigator sets it out pretty clearly. In 1999, Mr. Sweeney provided a doctor's note that said he has ADHD, but there didn't say what accommodations he needed, make the formal request. There is an interactive process at UPS. So you meet with the HR rep, the union rep, you work out the agreement, it's signed. That didn't happen. In 2006, he provided a doctor's note and they asked for more information. He never completed the process and it was denied. That's what the investigator said. That's what's in the record. Now, after filing this charge, during the investigative process, after the charge was filed, UPS went back to him because he's a current employee. He was always employed throughout the duration of this investigation and said, look, if you do need an accommodation, here's all the processes. And in fact, we will hold your hand and do it. I have text messages between him and the HR person saying, I'll meet you anytime, anywhere. You tell me when, we will get this done. And he didn't take him up on it for nearly 9 months. Finally, in August of 2020, okay, after this has been floating around, he goes forward, gives the medical records and says exactly what the accommodation should be. They have the interactive process. They meet with the union rep. In November of 2020, they agree. All parties agree to the accommodation. That was the first time that process was completed. That's issue one. Okay, the investigator actually spends quite a big deal of her report analyzing the issue. So to say it was just dismissed wholesale in a footnote is just wrong. The second part is the context of what happened here. And Mr. Baber mentioned the union grievance. I want to use the arbitrator's own words about this incident. Mr. Sweeney's behavior was, quote, offensive, plainly upsetting to the recipient of his wrath and worthy of serious discipline. This is an individual who left his area. He left his work area to attack a fellow coworker and called that coworker a useless fucking bitch. Okay, UPS does not have to tolerate that. And what's pretty interesting is that during the investigative process by UPS, where they interviewed him and 7 witnesses, he never brought up his disability or mentioned the disability as being a reason for this. During the union hearing with the arbitration, he never brought up disability or a failure to accommodate. It was only after filing the charge that this theory has come up. But as the investigator, and kudos to her, because this is a pretty big record with a lot of documents, was able to suss out and explain for you that the incident, the fight that he started, has nothing to do with ADHD. He left his assigned work area. He was working alone. He decided to initiate contact with another coworker and use vulgar language, you know, and attack her essentially. And this is not new. Okay, Mr. Sweeney has been a part-time employee since 1993. He's got over 30 disciplinary actions against him. He's got a great union. He remains employed, but UPS does not need to tolerate that. And it has nothing to do with an accommodation. So step one, right, is there was never an accommodation approved. But even if you find that there was, it has nothing to do with this incident. And that's pretty clearly set forth in the investigator's report. And then number two is all the other issues, which is you have an employee who, if this action isn't worthy of discipline, then really nothing is. And that's just not my opinion. You've got 7-8 witnesses plus the arbitrator's opinion. And with that, I'm happy to answer any questions.
Thank you, Mr. Silver. Hold on one second. Okay, questions for Mr. Silver. Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby.
I don't think so. Thank you, Attorney Silver. You clarified confusion that I think I'll take the blame for regarding the body of the report and then footnote 5. So well, I will ask a question. I interpreted the language in the investigator's report that explained what the doctor's recommendation was. I guess I made an assumption that that had been accommodated. That was the end of the analysis. But you're telling me that after that statement made by the doctor occurred, there was additional documentation requested by the employer, and then it just was never received by the complainant, and then therefore that's the reason why there was no accommodation.
That's right. In that incident, there is a more recent accommodation request which was granted.
I'm aware of that. No, my confusion was around the 2006. I made an assumption about what the investigator found as to what the doctor said. I made an assumption that an accommodation had been made. Thank you very much.
Commissioner David, questions to Mr. Silver?
Attorney Silver, he's discharged over this incident and then reinstated after the union arbitration finding. Is that right?
The union arbitrator determined that he should be that the discipline would be without pay, so that reinstate but without the back pay, because UPS should have disciplined another coworker for using vulgar language as well.
And how long is that without pay? How long does that take? How long is he out?
He was out about 75 days.
Okay.
So the arbitrator's opinion was this was worthy of serious discipline, and in her opinion, that was serious discipline.
And his allegation is that it's unlawful discrimination resulting in his discharge.
That's right.
Okay. Thank you.
Commissioner Dusan, questions?
So, Mr. Silver, your analysis, your presentation is that the employer, as far as the employer is concerned, there was never an accommodation? Or
there was never what?
A official accommodation plan signed on?
That's right. Prior to this incident, there was never a formal accommodation granted. And prior to this incident, Mr. Sweeney had worked in these various preload positions for years.
So I get the arguments as to whether the overall issue of the accommodation is appropriate to focus on. I just want to be sure I understand the factual presentation. And so as far as your presentation on behalf of the employer is, this accommodation of the disability documented by the complainant with information from his doctor, it was not considered in his assignments for any of this, the duration of this employment relationship, except at the end when there's been a formal accommodation.
That's right. And there's a small grouping of positions in this preload area. You know, and Mr. Sweeney's probably, I mean, I have to go back and look, he's probably worked in all of them, would be my guess. But he's certainly, employees have preferences of where they want to work, and but in terms of disability, no.
Okay, it occurred to me that thank you, Mr. Silver, that I did not mention there is a second respondent. They didn't make a timely post-report submission. I don't believe there's anybody here from them, but we should probably check if there's anybody here for Teamsters Local 340. I didn't think there was, but I thought we should ask. Okay, so then we just heard from Mr. Silver. I guess at this point we would go back to Mr. Baber. You have about just over 6 minutes remaining.
Thank you. Let me start with the first allegation that Mr. Sweeney's doctor back in 2006 did not specifically identify an accommodation. It's in the record. The investigator refers to it. Dr. Karen Hover's.
Mr. Baber, please don't use any third parties' names.
Oh, okay. Dr. H's letter is in the record, dated March 21, 2006, in which she tells UPS, we have discussed his current work situation and believe that he would do well and have fewer misloads if he stayed working on the same trucks for at least 6 months at a time, rather than changing trucks frequently, as has been happening recently. These would be appropriate accommodations for Sean Sweeney's disability. I don't believe the law supports Mr. Silver's next contention that there has to be a formal process. The employee may make the request, as Mr. Sweeney did through his union rights, assign me to this consistent preloader position. If the employer at the shop level agrees with that and doesn't ratchet it up, there doesn't need to be this formal process. We contend that the employer at that level agreed to place Mr. Sweeney in the pre-sort position consistent with the doctor's recommendations for consistency. And it was when the employer deviated from that pattern on 25 occasions, as Mr. Silver points out, it sort of begs the question, what's going on with these 25 instances that we keep having a termination, rescission, back to work, and there's a problem? It's because they're honoring the preload. He gets moved to a floater position. He objects to the pre-floating position, sometimes rather strenuously. He gets terminated. He gets brought back to work after some form of grievance process, and then things calm down for a little while. This is the record that should have been fully developed in this instance. And Mr. Sweeney has done so by referencing his disciplinary history throughout and attributing it to this failure to accommodate. Mr. Silver then conflates the reasonable accommodations claim with the termination claim. And as I indicated at the outset, I'm not here to litigate the factual details over it. There is another side to that whole story in which Mr. Sweeney dropped an F-bomb, but what's pertinent for this analysis is the fact he was taken out of his pre-sort position. This never would have happened had UPS honored that pre-sort position. That's the failure to accommodate claim. So everything that happens after that is beside the point with respect to failure to accommodate. Thank you. I'll take any further questions.
Follow-up questions for Mr. Baber. Commissioner Whitworth?
No question.
Commissioner Ashby?
Nothing, thank you.
Commissioner David?
No.
Commissioner Dusan? Okay, thank you. So then we'll turn to Mr. Silver. Mr. Silver, you have a little over 5 minutes left.
Thank you. And just to clarify, and maybe I used the wrong dates, but when I mentioned earlier, there were 2 doctor's issues. 99 was when the doctor's note doesn't ask for an accommodation. There's no denying the doctor's note in 2006, which is quoted in the investigator's report, mentions, he should remain on some trucks for 6 months, but that request was denied. I don't know why we're still arguing the point. It was denied. Whether you agree with the denial or not, it was denied in 2006. Mr. Sweeney continued to work at UPS for 13 more years. It still does to this day, but 13 more years until this incident. So if there was an issue with that accommodation request in 2006, what are we litigating it in 2021 for? And in terms of the disciplinary history, just take a step back and listen to the argument. The argument is all of the discipline, all of my outbursts, all of my vulgar language, all of my violent behavior cannot be attributed to me because I have ADHD and they denied my request 13 years ago. I'd point all of the commissioners, and as I did to the investigator, to the recent First Circuit case, Trahan versus Wayfair, which Mr. Sweeney's counsel knows very well. It's a very similar factual case, and the First Circuit felt fit to say that the ADA is not a license for insubordination at the workplace. And that's really the heart of this matter. And a lot of the prior discipline, just to correct the record that was presented to you, as the investigator properly set forth, most of those were for time issues. Being late to work has nothing to do with what position you're in, just showing up to work properly. With that, I'm happy to take other questions, but we're belaboring a point that passed in 2006. And when Mr. Sweeney followed the formal process in 2020, it was approved.
Questions for Mr. Silver? Commissioner Whitworth?
No questions.
Commissioner Ashby?
Nothing, thank you.
Commissioner David?
No.
Commissioner Dusson?
I have no questions.
Okay, thank you, both counsel. Now we would turn to the investigator. This also was a case investigated by Jane O'Reilly, and Kit Thompson-Crossman is presenting it.
Good morning, commissioners. My name is Kit Thompson-Crossman, presenting for Investigator O'Reilly. I will largely rest on her report and what you've heard already. I just want to reiterate that the most recent reasonable accommodation request was made in 2006, in the early part of 2006, on April 3rd, and these were documents submitted by complainant. On April 3rd, there's a letter from respondent requesting additional information. There's no response in the record from complainant to that request, and on May 22nd, there's a letter from respondent saying they can't grant the reasonable accommodation request with the information they have, and then there's nothing else in the record from complainant submitting more information. Jane could probably answer the question as to what the union's obligations are better than I. The record in this case is extensive, and she has probably a better memory for it than I do. But as far as I understand from the record, there's a clause in a union agreement that lets, let me just pull it up here, that lets part-time employees with seniority put their name on a waiting list for a position. I don't have anything in the record that I have seen, Barbara, correct me if I'm wrong, that says the union ever agreed to assign him solely to or to never assign him to the floater position. Am I accurate on that?
To the best of my recollection, yes.
Okay. And then the other thing that I'd like to point out is that with regard to his discharge, as Jane pointed out in her report, the things that led to the incident are not referenced in the list of symptoms that are provided to respondent or the list of things that might result from complainant's ADHD diagnosis. And it's never mentioned in the grievance process that he follows through on. He doesn't reference it. The person who writes the decision in the grievance doesn't reference it. It's not referenced at all until this complaint is filed. With that, I'm happy to answer any questions that you have to the best of my ability.
Thanks, Kit. Questions for the investigator, Commissioner Whitworth? No.
No questions. Thank you.
Commissioner Ashby?
No, thank you. That's very helpful.
Commissioner David?
No, I agree. It's very helpful.
Commissioner Dusson? You were
No,
muted?
I have no questions.
Okay, thanks, Kit. So having heard Having heard from the parties and the investigator, usually we would give a motion or motions. There are two proposed findings. You can take them separately or together.
I propose to take them together and move that we find that there's no reasonable grounds to believe that UPS or the Teamsters Union discriminated against the complainant on the basis of disability, and no reasonable grounds to find that there was retaliation, and that the complaint should be dismissed.
Second.
So it's been moved and seconded. Is there any discussion?
Just speaking to my own motion, it's clear to me that it's not a failure, even if there was an obligation to accommodate or an assumption that he'd been being accommodated for many years. It's clear that the behavior is not the result of his disability, and the assumption in the complainant's presentation is that his disability is a justification for any untoward behavior. And I'm persuaded by Attorney Silver's presentation.
I'd say that the but-for argument is attractive. But for the failure to accommodate this disability, he wouldn't have been in this maybe position, and then if he hadn't been required to be floating, this wouldn't have happened. I mean, but I didn't give that much. I mean, we didn't assess that very carefully after I was convinced or satisfied that, in fact, there was no granting of an accommodation. And there was some confusion clearly on my part from my questions. You saw there was some confusion on my part as to whether it had been granted. But once I'm convinced that no such accommodation was sort of properly presented such that it could have been granted. In fact, it was denied apparently without any further follow-up by the complainant. I think we don't get to that second part. And then I agree quite clearly.
Lost your last sentence, Mr. Asher.
It sounds like Ms. Dusan couldn't hear your last sentence.
I'm sorry. Oh, then I feel once we don't get to that analysis, I think that termination is entirely appropriate under these facts.
Any additional discussion from commissioners?
Commissioner Dusan.
Yeah.
Go.
Yeah.
This is an excellent investigative report that cuts through a lot of detail to a conclusion that I support. I did feel the need to ask more questions and understand more about the reasonable accommodation allegation, but on the response of both counsel to those questions, I will be voting in favor of the no reasonable grounds findings. I conclude that the termination was not related to the stated disability.
Any additional discussion from commissioners? Seeing none, the motion is to find no reasonable grounds to believe unlawful discrimination happened based on disability or for retaliation. All those commissioners in favor, raise your hand and say yes. I see
Yes.
1, 2, 3, 4. So the finding is no reasonable grounds on both claims. And we have 2 cases left, but I think, Deb, did you say that there was a request for a break?
Yeah, we're going to take a 5-minute break. So if we could come back at exactly 10:58, we'll resume our meeting. Okay, let's call our meeting back to order after our break. Our next case, do we want to try for E19-0241AB again, Amy?
That's really up to you all, whether you want to call that one now or call it at the end. Up to you. I think the complainant has been given an opportunity to appear. We have not gotten, as far as I know, any emails at our office to say they can't connect. We don't have enough staff to answer the phone live at this point, so maybe they've left a message, but we haven't gotten it.
Okay. Then let's move on to H20-0423ABC. This is a reasonable grounds case. Christopher Buckley, Mary Buckley, and Mariah Buckley v. Stephen Gravier, Bonnie Gravier, and Joshua Marr. Is there anybody here for the respondent?
Oh, Mr. Wilson, you're muted. Mr. Wilson is here for some of the respondents, and Ms. Glenn is here for one of the respondents. I would just say before you start, I do just want to remind folks there are some redactions to the Graver's submission. The commission has gone back and forth with Mr. Wilson extensively about that, and I just want to let the commissioners know that if he strays into the remarks that are redacted, I will have to intervene. I don't want to do that, so just putting that out there.
Yes, good morning, Commissioners, Executive Director, Attorney Glenn, Attorney Ender. I'm here on behalf of Bonnie and Steve Graver. I'd ask to reserve 3 minutes if I could.
Sure.
Thank you for having me, everyone. I'm going to eventually ask that the commission make a motion and not adopt the findings of the investigator in this matter, and that there was no unlawful discrimination by the Gravers. As you know, this is a landlord-tenant situation. I'm ultimately going to be arguing for 3 reasons why there was no unlawful discrimination in this case. The first is the facts of the case do not support any unlawful discrimination. Secondarily, the law, as it currently stands under recent case law, does not support that there was any sort of constructive failure to accommodate in this matter. And lastly, that there was accommodation. Starting with the facts, the timeline of this case is so key to understanding why there was no discrimination. There's no dispute in this case that the Buckleys have been long-term tenants of the Gravers. They lived in a home that had previously had a ramp attached to it. As the report indicates, it's Mr. Graver's contention that the last he knew, Mr. Buckley was able to navigate the stairs. And then a key date occurs. The state had indicated to Mr. Graver that they needed to have a lead abatement done to this property immediately. COVID delayed that. So the lead abatement began on September 9th, and the Buckleys moved into a hotel. 2 key things happened after September 29th, September 9th and September 21st. The first is that eventually the state, after the lead abatement was finished, said that we cannot grant an occupancy permit to this residence if you attach the old ramp to the home. Additionally, they said that we cannot provide funding for you to get a new ramp. That happened during that time period between September 9th and September 21st. The second thing that happened during that time period is that Mr. Buckley, the tenant, had a surgery. We don't know the date, but had a surgery to remove a part of his leg that made him more permanently wheelchair bound. On September 21st, eventually the state granted Mr. Graver occupancy for this residence, and he allowed the Buckleys to move back in. There was no ramp because there hadn't been one given, there hadn't been funding given for one. Miss Buckley moved back in on September 21st. The next thing that Mr. Graver knew was that he was given the letter that I attached to my brief that you should have on October 2nd of 2020. As you can see, the first condition issue that Mr. Graver was told by the Buckleys after they moved back in said nothing about the ramp. Moreover, that same day that that letter was issued, Mr. and Ms. Buckley went to the commission and filed their complaint for failure to accommodate. There is no dispute that that surgery was never told directly to Mr. Graver or Miss Graver, that they were never given notice of that surgery during that intervening time. And the first thing they heard was an October letter that mentioned nothing about a need for a ramp. The last thing Mr. Graver knew was it was his understanding that Mr. Buckley had access to this apartment via the stairs and was able to use them. After Mr. Graver had notice of this complaint, there is no dispute that within a very quick and reasonable amount of time, he had a beautiful ramp installed on the side of this home that exists to this day. As the investigator pointed out, that was a very short period for Mr. Graver to be able to install that ramp. That is not discrimination. He was prevented by the state from putting a ramp back on this home. He's caught between a rock and a hard place. Either I can tell the Gravers that I'm not ready to put you back in because I don't have occupancy, you have no access to your home, or I can open it up as best I can, which he did. Ms. Buckley moved back in and he had a new ramp installed less than a month after the notice of this commission complaint. Those facts, that timeline simply does not support that Mr. Graver unlawfully discriminated. And I would note that the investigator's report is devoid of any sort of intent, any sort of statement, letter, anything that would demonstrate that there was any malicious intent on Mr. or Ms. Graver's part. That's the factual argument. Second, as I cited, this is more phrased as a constructive failure to accommodate because there was never, as far as the record can show, an affirmative post-surgical request for that ramp. It was simply, there was one there, you had this work done, and you didn't get it put up in a timely manner. That's where the findings come down. In the constructive failure to accommodate cases, there's two elements. One is it has to be an unreasonable amount of time. And I would argue from the 21st, when the occupancy permit was issued, to the October 23rd date of a month, and less than a month after the complaint, and less than a month after that letter that did not mention the ramp, Mr. Graver had a beautiful ramp installed. That fails the first element of constructive failure to accommodate. Secondarily, the case law demonstrates there has to not only be that unreasonable delay, but some malicious intent for the unreasonable delay. And in fact, the longer the delay, the less of there needs to be maliciousness because the delay proves the maliciousness. That is not the case here. There's nothing in the record that shows any intent or malicious thought by the Gravers. It was the realities of the post failure to fund the ramp reattachment to the home. There's a ramp there now. So I would argue ultimately, ladies and gentlemen, that this petition fails on both grounds. The facts, the timeline don't support that finding, nor does the law as it currently stands. And I would ask that the commission respectfully overturn the findings and not adopt a finding that there was an unlawful discrimination in this matter. Thank you.
That is under your 7 minutes by a few seconds. Questions for Mr. Wilson from commissioners? Commissioner Whitworth.
Not at this time, thank you.
Commissioner Ashby.
Just a couple. I see in the notes attached to the investigator's report, the summary of interviews, and there's the summary of an interview with Mr. Marr, who I understand is not your client. Is that correct? He's not your client?
That's correct. He was the contractor on the matter. He's Attorney Glynn's client.
Right. So do your clients have any opinion about the conversation that happened between the complainants and Mr. Marr, where it appears that Mr. Marr said, yeah, I'm not putting the ramp back on again, and it's just not going to happen. It's not my problem. Too bad. Or I'm paraphrasing, but that seems to be the sort of dismissive nature of his comments.
My understanding is there's no dispute that the Gravers never knew about that there's no dispute that they were never given that sort of notice, that they never had that conversation with Ms. Buckley.
That was my next question. Is there anything in the record that indicates that he then subsequently spoke to your clients? And you're saying no, that there's nothing in the record to that effect?
No, in fact, I think it's just the opposite. My recollection is that the record reflects that that was not done, that was not relayed to the gravers.
Thank you.
Commissioner David, questions for Mr. Wilson?
He paid for the ramp ultimately, correct?
Mr. Graver did, yes.
Okay. In those investigators' notes describing the interviews, it's said that he said the ramp was not his problem. Do you deny that that was said?
Can you reference a page?
I think it's on page 7 in paragraph A. That's where I noted it in my note to ask the question.
And I apologize. Could you point a little bit more specifically? I can't seem to find it quickly.
I'm not seeing it myself now. I'll have to look further, but I wrote it down in quotes that there were multiple discussions about the ramp while they were out, and that the gravers said it's not my problem, which is supported by the fact that he's relying on the fact that the abatement people are saying we're not funding it, and then he decides to go and replace it. Correct? Is that the correct sequence?
Commissioner David, if I may, I think that your questions go to the questions that I asked, and it's the second. I'm sorry, it's the very first paragraph on page 8, which references Mr. Marr's comments to that effect. I believe Mr. Marr is allegedly the person who said that the ramp was not his problem.
That was my recollection, and I didn't want to step on your
Okay.
toes, Commissioner David, but my recollection is there was no dispute that Mr. Marr, the contractor, had said things to that effect, but there was nothing in the report to indicate the gravers knew nor had said anything like that.
He was relying on somebody else paying for it, right? He didn't make any arrangements to have that work contracted for.
He did, Commissioner. What had happened was the Lead Abatement Commission for the state teams
Right.
up with Community Concepts, and Community Concepts, I believe, paid for 80% of this project. And then what had happened was, in order for both Community Concepts and the Lead Abatement Commission to approve of the work and say that it's cleared for habitation, both they have an inspector come out, and the inspector for Community Concepts and the Lead Abatement Commission came out and said, yeah, this looks great. The lead abatement was done really well, but if you attach that ramp that was on the home, we are not going to give you a habitation permit. And so on September 21st, when the work was done, the habitation permit was only granted because the ramp that was there was not attached. Mr. Graver asked Community Concepts very directly, well, what, you're leaving me in a tough spot. I don't have the money. Do you have the funds to give me?
Mr. Wilson, I'm sorry to interrupt. The investigator is indicating that something you've just said is not in the record.
This part may be in the record. I'm just worried it's going to get into more details about the conversation that's not in the record.
Oh, no, I was almost done, actually. I mean, essentially what happened was he went to Community Concepts and simply said, can I have the funding for that ramp? And Community Concepts said, no, we don't have the funding for the ramp. The funding was for the lead abatement. And that was the end of Community Concepts' willingness to aid Mr. Graver. So he had to go out and fund the ramp by himself. And it took
Okay, somebody has something on. Okay.
Excuse me, when is he told that Community Concepts is not going to pay for the ramp?
It was right around the end of the project. I mean, that my understanding, and this is the hard part, I don't want to go beyond the redactions, but since it was asked, it was right around the end of the project. I believe construction ended the 20th. And it was right around that point that he went to go get the permitting. and was told, you can't have the permit if this ramp is on.
And I do have another unrelated question. Is there anything else that's other than what's mentioned in the report leading up to the notice of the rent increase? Is there any discussion with them by the owner that we're going to need a rent increase? We're planning one. There hasn't been one. Whatever the discussion might be.
No, I believe, in fact, the rent increase notice was actually given via a letter. There wasn't a discussion about that. That was a letter left, is my recollection.
All right.
The discussion concerning that, and I would just say, I think this is in the record, stop me if it's not, but the conversation concerning that was more between Mr. Graver and personnel at the state, because he was concerned about recouping a lot of the cost he had put in, the sort of co-pays with community concepts. And so he had some discussions about what do I do? And that's when the rent increase was suggested to him, and he gave notice of that via writing. So
and those costs that he's concerned about at that point then are both the ramp and his 20% not paid by community concepts?
that's correct. My recollection is the total of the co-pays that Mr. Graver had to put into this project was ultimately total around 70,000. And then on top of that, he had to come up with the money and find a ramp during COVID. And it took him a month. There's not an easy way to say that a month is not unreasonable during this period. And it wasn't even really a month. If you consider the notice of a ramp, the 2nd of October, that they're actually saying, we had a surgery, here's the complaint from the commission, we need a ramp now. 3 weeks to have all of that completed, I think is noble. And the ramp he put in is beautiful.
Thank you.
Commissioner Dusan? You are muted.
Yes, thank you. I'm trying to sift out the relationships here. I understand that the owners of the premises are arguing that they were not aware of the need for the ramp, the additional need for, heightened need for the ramp, heightened by the health condition of the complainant's husband. And I understand that the putting the ramp up was expensive. But I'm concerned about the relationship between the owners and the contractor who was, I'm trying not to say names, the contractor who was replacing the ramp for the abatement. The contractor who's doing the abatement is the son-in-law of the owners.
That's correct.
You can say his name. He is a named respondent.
Oh,
Mr. Marr is a named
much.
respondent.
Whew, I was struggling with that. Now, what popped out at me in the record also on page 7 is that made me question the kind of the distance in the relationship between the abatement contractor and the owners. And the little gem that made me question that is this note that Mr. Marr's wife is the daughter of the owners. And there's not a challenge from Mr. Wilson. I'm asking, you're not challenging that there were a number of conversations with Mr. Marr over a period of time related to the need for the ramp to be there when the tenants were ready to move back in.
No, I am disputing that. I mean, I think that the record is devoid of that. I mean, there might be a familiar relationship, but Mr. Marr was more or less contracting with the state. The contract runs between the state and Mr. Marr. The community concepts are the ones running this program. So they come up with a plan, they give him a contract, and he runs with it and finishes what they order. So there may have been a familiar relationship, but that was between Mr. Marr and the lead abatement and community concepts folks. But there's, I mean, what we are.
I'm sorry, thank you, Mr. Wilson. Are you questioning or disputing that there were a number of conversations between the tenants and Mr. Marr about the ramp?
It doesn't, I would not dispute that. It sounds like, I mean, it sounds like Mr. Marr and the tenants did at least have some sort of, at least one discussion from what we can
Well,
tell.
at
but-
least in order to get to the point of him saying it's not my problem. So what concerns me is this note that complainants were informed that Mr. Graver's daughter, also known as Mrs. Marr, was going to be taking over the rents for the owners, which implies a relationship that I'm between. So, you know, maybe these 4 family members never talked to each other, but I just am having trouble with the notion that the Gravers had no idea that the ramp was important.
I think they ultimately did believe it was important. That's why they put it in. The issue became that they had when they last saw Mr. Buckley, when they were last dealing with Mr. Buckley, he was able to use the stairs. Footnote 2 to the investigator's report demonstrates that even the investigator can't come to a conclusion as to whether that is any different. And so the last time that Mr. Graver saw this tenant, he was able to use the stairs. There's the lead abatement process, and there is nothing. I mean, people can speculate there. I mean, it sounds like, Commissioner, there's a lot of speculation, but there is certainly no indication that anything was passed on to Mr. Graver. There is no doubt that Mr. Marr had conversations with Miss Buckley. I would guess that they came into contact quite a bit, her being the actual tenant and him being on the ground at the location doing the work. But Mr. Graver didn't. I mean, there's no dispute about that. There's just no dispute that he didn't have those conversations, that Mr. Marr didn't pass that on. All he wanted was that work to be done. That's the only thing. I mean, obviously, I would guess, suggested his son-in-law as a contractor to the people telling him from the state that you need to get this work done. And then Mr. Marr takes the lead with the state and he finishes the contract. He's on the ground. Mr. Graver is just waiting for this whole process and nightmare to be behind him. And then unfortunately, the nightmare continued when instead of saying we're done, they left him high and dry with no money and no ramp. And so he did the best he could to get one up.
Okay.
Thank you. Mr. Wilson, we will come back to you after we'll come back to you in a while. Next, we'll go to Ms. Glynn on behalf of Mr. Marr.
Thank you. Mr. Marr's involvement of this in this case is solely contractual. He was contracted through the lead abatement contract, and his only obligation and responsibility was to that contract. If the if the Buckleys had a side discussion with him, they certainly didn't ask him to relay anything to the Gravers. And the Buckley's obligation would have been to direct a specific complaint to the Buckleys directly, as they have they were the ones that were bound to do the reasonable accommodation. So Mr. Marr had no relationship or responsibility to affect the ramp issue or address the ramp issue with either the Buckleys or the Gravers. As far as the comments that were just made about Mrs. Marr taking over rent, I have not discussed that with my client. I don't believe he had any knowledge of that. And certainly, again, he had no business relationship with the Gravers regarding their rental. And again, his involvement in this case was strictly related to his compliance with the terms of his contract and the limitations of his contract, as laid out in this interview with Ms. Crossman. As it says in the investigation, he could put a ramp back on, but it had to be cleared by the agency, and he had to do exactly what was laid out in the contract, and that's what he did. We, of course, agree with the investigator's findings that there's no finding of unreasonable accommodation, that Mr. Marr did not unreasonable, no finding against Mr. Marr. Thank you.
And actually, thank you, Ms. Glynn. I just realized, thank you, Barbara, that I should not even have asked Ms. Glynn to say anything because there is a no reasonable grounds proposed finding and there was no objection to that. So that was my mistake. Thank you, Ms. Glynn. Well done. But there's no objection. to the proposed findings. So it's as if you didn't say anything, but you did it really well. So sorry, my bad. We have heard from the respondents, the Gravers, and now we would turn to hear from the complainants, the Buckleys, and I believe Miss Ender is here.
Yes, I'm here.
Okay. Go ahead.
Thank you. So, Mr. and Mrs. Buckley are here, and their adult daughter is also a complainant in this matter. When Miss Buckley, mother and daughter were ready to move back in, it was before they moved back in before Mr. Buckley was released from rehab. However, there was no requirement that they provide notice of their need for a ramp. Mr. Buckley had struggled with stairs for many years and hadn't been able to use stairs for many years. Mr. Graver said, there's a note that Mr. Graver said that Mr. Buckley could navigate the stairs just fine. That's just, whether he's thought that or not, it's never been true. And Mr. Buckley has said, the complainants have all said, Mr. Buckley could not navigate any stairs at all. So when they moved to the unit years ago, they had specifically asked to move into that unit because it had a ramp. And they paid extra every month for $150 more than other tenants did for that unit, month after month after month. It's true that it was a funky ramp, and it was safe, and there was no issue with it. When it came time, when Community Concepts did the flood abatement, it's black letter law that when something falls out of compliance, it can't be approved. So it can't be, the old ramp could not be restored because it's correct. It didn't meet code at that time. And so there needed to be an accommodation. While Mr. Graver was in the hospital and he came out of the hospital, he had no way to get into the apartment, period. And it's true that the Gravers found a ramp, but Ms. Buckley's attempts to find out what was going to happen and how was her husband going to be able to get into the apartment went unaddressed by anybody. They just basically blew her off. Mr. Buckley had a series of medical evidence and medical issues, but that really wasn't any of the Gravers' business because they already were aware that Mr. Buckley needed a ramp and was paying for a ramp and had no way to get into the apartment when there was no ramp. There is, the investigator noted that there was another barrier to the properties that kept Mr. Buckley from being able to access his home. So he was left. I mean, this was very, very hard on the family, even for any period of time. It was the first stage when he got out of the hospital and couldn't return home was fairly short. But we filed a commission complaint right away. The date the commission got the completed complaint was October 7th, perhaps. But the meeting with the commission paralegal to notarize the complaint was on October 1st or 2nd, and then it had to be mailed in. So this is part of the remote situation from COVID, and where the governor has allowed remote notarizing. But the notarized complaint has to physically be presented to the commission before the case is open. So Ms. Buckley is trying her best to communicate to whoever will listen And it's not really her fault that the Gravers did not want to hear and were not available. I mean, they used to be around a lot, or Mr. Graver used to be around a lot, and he disappeared. He went dark. So they had Mr. Marr to talk to, and they did repeatedly, and Mr. Marr was of no assistance. There is a family relationship, and originally we alleged that there was agency. We did not challenge that finding that there was no agency relationship there, but it is inexcusable that the Gravers ignored that Mr. Buckley needed a ramp to get into his apartment, and then there was no ramp. We are grateful that a ramp was provided. However, there was another barrier put in place where Mr. Buckley still could not access the apartment because of this block of wood at the threshold. When he used to be able to get into the apartment, and now he couldn't get into the apartment.
Hold on. Whoa. Mr. Wilson?
Yes, these things were actually taken out of a supplemental investigation and shouldn't be being addressed.
I actually think that I'm the one who gets to make that point. I understand that you think that there are things that are not in the record. Things that were redacted from your submission are not the same as what Ms. Ender may make points about. I'm counting on the investigator to indicate to me what is in the record and what is not. You have messaged me that the information about the Buckley's attempts to get in touch with the Gravers are not in the record. I said to you in the message, I'm looking at the investigator to indicate to me if something's not in the record. So that's what we're going to go by. And we're not going to hear from the Gravers right this minute. We're actually hearing from your counsel. So you may want to, we're hearing from the complainant's counsel right now. So Mrs. Graver, I'm going to put you back on mute for now, Mr. and Mrs. Graver. I suggest that you guys connect with your attorney about who's going to present on your behalf when we get back to your turn. But right now it's Ms. Ender's turn.
Thank you. I haven't heard anything that was not in the record thus far.
Thank you.
You have about 4.5 minutes left, Ms. Ender.
Thank you. In terms of, there's no necessity for malice in this failure to replace the ramp in a timely fashion. The Gravers were not getting any information. I mean, the Buckleys were not getting information about when Mr. Buckley would be able to return home. This was a great problem for the family. I mean, he wanted to be home, as many of us would, and he could not get home because he could not get into the apartment. And he had access, prior to this, he had access to the property. After the ramp was removed, he had no access, and there was no promise of when this was going to be addressed. The ramp showed up overnight on October 23rd. And then there was yet another barrier, which remained at the time of the investigator's report, which remained a barrier. To this day, I'm not sure if it's been resolved or not, but at the time of the investigator's report, there was still no independent access, and Mr. Graver had independent access until that time. I have to say for now.
Okay. Questions for Ms. Ender, Commissioner Whitworth?
No questions.
Commissioner Ashby?
No questions, thank you.
Commissioner David?
Attorney Ender, the third, you obviously agree that there's reasonable grounds to believe there's been discrimination. The first two proposed conclusions. The third is that the investigator recommends that there's no reasonable grounds in regards to retaliation. Do you argue that the rent increase is retaliation?
We did not object to that.
You do not object to that third finding?
Right. I didn't make any objection to the investigator's report. So okay. I did not challenge the lack of agency, and I did not challenge the retaliation piece or the rent increase issue.
Okay, thank you.
Thank you.
Commissioner Dusan, questions for Ms. Ender?
Senator, I understand that, so the issue I'm trying to work on here is access to the apartment, access to living space for a person with a very specific need for a ramp. A beautiful ramp is fine, but a ramp that's functional is the most important thing. And I want to know, unless it was not discussed in the investigator's report, how long the block that you mentioned, you mentioned there was another hurdle to access to the apartment, which was not resolved by the ramp, or might have been exacerbated by the way in which the ramp was installed. Can you tell me how long that was? Was there a period after the time the ramp was installed, but there was a additional hurdle to getting into the apartment that because of which Mr. Buckley was not able to access the premises?
I don't know when that was resolved. It was resolved, I believe it has been resolved, but I don't know for sure. But as of the date of the investigator's report, it had not been resolved. So there was a ramp, and then there was a pathway, a wooden pathway, and then there was a 2x4 with, that Mr. Buckley could not get over. That was the threshold to the unit. The record has a lot of photographs of this, of piece by piece, and of what barriers Mr. Buckley had in getting into the unit. Okay. So there was a period that lasted, the investigator's report is dated January 11th, and as of that report, the barriers, there was still no independent access for Mr. Buckley.
And do you mean by that Mr. Buckley was unable to enter the premises? Move
right
back into the premises?
Well, if he was, it was because his son
physical assistance
would physically have to lift him, and he's a full-grown person who needed to be lifted from a wheelchair that was on one side of the threshold onto the wheelchair that on the other side of the threshold, which could not be rolled over naturally.
Thank you. So that time period was at least until the date
October
on the
11.
investigator's report, which is January 11.
January 11, excuse me, yes.
Thank you.
Thank you. I'm trying to determine, and Kit, perhaps you can help me with this. I just need to make sure that the commissioners all received the supplemental report, because the report that I'm looking at is dated January 11th.
Yeah, I think that is just an error. I think that, so can I just address a little piece of the timeline here? The report was issued originally on January 11th. We received a submission from respondents that led me to reopen the record for a period of time to invite a further submission. I got that submission, I closed the record again, I rewrote the report, I reissued the report, and I believe this one should in fact say February 11th and not January 11th. I think that piece did not get changed when it was issued. And that's a Scrivener's error entirely.
But so as the right report, Kit?
It is the right report.
Okay.
I'm pretty sure. I don't, right. Let me just, let me look at my email and make sure. I'm 99% sure that the one you have is the one that you should have.
I just wanted to check. I believe you're correct, but I just need to make sure that everyone's looking at the most updated version of the report.
One moment.
If I may say so, the report is correct. It just wasn't dated for the updated information. So if February 11th is correct, then there still was not independent access for Mr. Buckley on that day. But it remained unresolved. And again, today is March 15th. I personally don't know if it's been resolved.
Yeah.
Record is closed.
Amy, I'm looking at the report that got sent out on February 11th, and it does not match my final report.
Okay.
So I'm not sure what happens there, because I was thinking this is weird because my final report doesn't say anything about a structural impediment.
And the version of the report.
I didn't mean to be rude about that. That's what I was trying to get at, and I apologize for jumping in.
So it is possible that we are in the middle of a hearing on a version of a report that is not correct. And we need to pause, and it is possible that we may need to hold this hearing next month again, when we are sure that the commissioners have seen, I know the parties have seen the updated version of the report. And I know that the attorneys have submitted their comments on the updated version of the report. But I am not at all sure that our commissioners have seen the updated version of the report. So until I can be certain of that, we cannot proceed. And I am truly very, very, very sorry to everybody who is sitting here and proceeding in good faith and with all of their effort and the time that you all have committed to this. I am terribly sorry, but I cannot allow the commissioners to proceed without the correct version of the report. And I don't believe that they have had the opportunity to see that. So I'm gonna have to ask that we table this until our April meeting. And I'm very sorry for that. Mr. Wilson, to the Gravers, to the Buckleys, to Ms. Ender, to Ms. Glynn, I am very, very sorry. You didn't do anything. This is on us. But the commissioners need to have the updated version of this report, which does address the issue of an issue about accessibility of the premises. They have to have the right updated information. So I'm going to ask that the commissioners vote to table this case. And I am sorry to say that I'm going to have to ask council and the parties to return for our April meeting. I'm really very, very, very sorry. If someone has a better suggestion, I'd love to hear it, but I at the moment, that's the best I can come up with.
I would just ask that when you send the report to the commissioners, you also send it to us, so everybody we know for sure has the same version of the same report.
Absolutely. And yep, this is totally on us. We will make sure that when we send it to the commissioners, that everyone is looking at the same document and everyone has an opportunity to check that. The respondents and the complainants, I will not, there's no reason to open it back up for submissions. You had your time. We've got those. The only thing that has to change is that our commissioners need an opportunity to look at the updated report.
I move that we table this case until the next opportunity for us to meet and discuss it.
Okay.
It's been moved and seconded. Is there any discussion? Ms. Doosan? No, we can't hear you. You're muted.
Sorry. If between the two reports, there's a change in a factual finding by the investigator having to do with this 2x4, at some point, will I know what's been removed or what's been added? What the specific difference in language between the two reports, or will I just get the new report? Well, what I hope not to be is that I get the new report and then I have to do a comparison myself to figure out what changed.
Generally speaking, we would not do a line by line redlined version because you should never have gotten the first report. Honestly, you should only have gotten the second report.
May I ask a question?
You may.
My only concern is just that, as I was referencing when I was objecting, that bit about the 2x4 was what was specifically taken out, and that should have never been brought up. And I'm
Right.
concerned about the prejudice to my clients now that the commissioners are aware that there was an allegation that was now, it has been written out. There was no findings on it. I believe that the respondent made arguments to the original report despite having the new report, knowing that that was not the final finding. And I'm concerned. I think it's
And again, Mr. Wilson, I completely understand, but I'll also point out that the only reason that it was redacted is because you submitted it after the close of evidence. So I think you're not in the best position to be arguing at this point about prejudice. I understand your concern. I absolutely do. At this point, what has already been argued here has been argued. I cannot unargue it. I think both sides.
Sorry.
What?
I don't mind being instructed to ignore it. I just want to be sure that when I get the new report, I'm
Yes.
going to be able to figure out what's going on.
Amy, I'm sorry. Can we table this? I'm looking at too many versions of things right now. I'm looking at my final draft, which should be the one that went out. And I'm looking at the one that Joan mailed out on February 11th. Sorry, I'm just having a hard time figuring out what's going on. My computer is also.
Honestly, I don't think that we can answer it as we're sitting here. I think we need to be sure, and I don't think we are sure right now. And I don't think, I would like to be wrong. Yes, Commissioner Whitworth?
I just want to speak to Mr. Wilson's concern that the commissioners have information that we might not should have had and that we've heard things. I think you have to consider that we're professionals and that if we're not supposed to consider something and we've heard it, we won't consider it. So please put that fear aside. I don't think that it's a fear that you need to have.
Thank you. I appreciate that.
So that's a better way. That's what I should have said. I will note there is a pending motion, and at this, technically, we shouldn't be hearing from everybody else. Technically, there is a motion on the floor. So at this point, the discussion should be between the commissioners. There's a motion to table that's been seconded. And I will assume that all mistakes to abandon that motion. Nope, Ms. Ender, not right now, unless you have something that will completely define the issue and tell us that the commissioners have seen the proper version of the report, unless you can say that.
I think I can say that. I just looked at my email, and my email dated February 11th from Ms. Thurman has a January 11th, 2021, whatever this year is, 2021 report, and that's the report that I was addressing.
Kit has also messaged me saying you have the right version of the report. Barbara, is that your understanding as well? You're muted. You're muted. You're muted.
I am trying to pull them both up right now and see what's happening.
Everybody just pause for a minute. I actually do not see the issue that led to the revised report referenced in the version that you're looking at, which leads me to believe that you are looking at the correct version of the report that was misdated.
Yeah, okay. I can clarify this, I think. So there is the report, the final report is misdated, and that's a scrivener's error. I'm happy to take the blame for that. When I rewrote the report, I did not switch January to February, which I usually do. I missed it. I apologize for that. That was my error. The report that you have that Joan issued on February 11th, which should say February 11th, not January 11th, is my final report. I apologize for the confusion. There are several drafts of this report on my computer because of the record reopening, drafts that I submit to Barbara and then get back. This is the one that matches my final report. I'm happy when we get to it, if we get to it today, to address the structural impediments as I have them in the record. But for now, what I will say is you have the correct version of the report. I apologize for the confusion.
I'm going to attempt to withdraw my motion to table.
Actually, it was Jeff's motion.
I think it was mine, but either way, I'll withdraw mine, or we can all vote it down either way.
All right, hold on. I got to write this all down for the minutes.
And I have confirmed that Kit is correct. This is the right version of the report.
All right, so hold on. Jeff had made the motion to table and Ed had
Jeff.
seconded it.
I had seconded, yeah.
So I think, Ed, do you need to withdraw your second?
Yes.
Okay. Okay. Well, that was super confusing. I appreciate everybody patiently staying with us. That's a new one for us. So where we left off, I believe, was that we had heard first from Mr. Wilson on behalf of the Gravers, and briefly and mistakenly on my part from Ms. Glynn on behalf of Mr. Marr, and we'd heard from Ms. Ender on behalf of the Buckleys. Now, I believe we had just finished a round of commissioner questions for Ms. Ender. So we would be going back to council for the Gravers, who has about 3 minutes and 15 seconds. Due to this tremendous confusion, I'm going to say take 5 minutes, just in case there's anything else you want to address.
Could I just, do you mind? I'm trying to wrap my head around which one was referring to. Could I have maybe 15 seconds to make sure I'm pulling up the correct report?
Yes.
Thank you.
Yes, absolutely. And I just want to, again, I'm going to blame this on myself, but also the fact that we're all remote and it's confusing with what things we're sending and looking at. So COVID, it's COVID's fault. That's what we're going with for now, because that's better than it being me. So COVID's fault. And to the Buckleys and the Gravers, just let me say, I'm sorry. This is not normally what our meetings are like. We are usually better than this. I'm sorry that this has to be your experience seeing the commission in action. But we're not done. We could get rapidly better.
Could we also welcome Jill?
Also, Jill, you know we're usually better than this. Yeah, okay. Good thing you're muted. Okay, good. Yeah.
If I may.
Of course,
Yes.
you're very
Thank
much
you very
better than
much.
this.
So I'm responding to Attorney Ender's comments. And there's 2 major ones that I think I would like to respond to for the commission's benefit. One is that there was numerous references by Attorney Ender that they reached out, that they tried to contact the Gravers and were blown off. I see nothing in the record. That was actually a little bit of a surprise. I know of the conversation with Mr. Marr. That is certainly in there. There's no dispute that that was passed on. I'm not aware of anywhere else in the records that it would demonstrate that the Buckleys reached out to the Gravers and made any contact to try during this period to tell them there's a surgery, the ramp needs to go back on, he's in a wheelchair. In fact, on page 7, it's made very clear under the Buckleys interview summary that they say the Gravers did not know about this surgery. So I would argue that they may have reached out to Mr. Marr, but there was certainly no additional efforts to contact the Gravers. They just didn't know. And then the second thing I would address is what has caused this big issue right here. If I have the right report in front of me, sort of to give the commission a little bit of a procedural background, Mix Thompson Crossman had issued a report, and the report was for failure to accommodate. And there was a vast dispute after the report was issued about the current status, because I believe the initial report had mentioned that this 2x4, that the lip was not addressed. And what I believe the executive director is referring to is that there was new evidence to demonstrate that the Gravers, the Buckleys were actually accessing this, that the lip had been addressed. And I'm not sure if it's a Scrivener's error or not, but I'm sort of confused by the language that caused this issue, because the Buckleys certainly had access to the apartment. They have had access to that apartment since November, early November. Those issues were always consistently addressed by the Gravers over and over. They are actually in the apartment. And so when you read the report, I'm wondering if maybe, and again, the investigator is better suited to this, but the sentence reads that the ramp is satisfactory. And I believe that this is on page 2, correct. Sorry, 2. That the ramp had been installed, it was compliant, and the parties agree the ramp itself is satisfactory. And then it goes on to say, however, Mr. Buckley is still unable to access the premises because of a structural impediment where the ramp meets the door. And that was precisely what we had addressed in between the first report and the second report. And I had been on the understanding that everyone was agreeing at that second report that the ramp was now satisfactory, as that lip had been addressed. Pictures were sent in regarding the lip. And we actually had provided pictures that Mr. Buckley was up on the decking of the ramp and had accessed it. And they are currently in that home. So I think that, I'm not sure if that was a clerical error between the 2 sentences or something that wasn't taken out, but I would argue that that is certainly not the case and hasn't been since early November.
Thank you, Mr. Wilson. Follow-up questions for Mr. Wilson, Commissioner Whitworth,
No questions, thank you.
Commissioner Ashby,
No questions, thank you.
Commissioner David.
Oh.
Commissioner Dusan.
Yes. There's an important factual item that I'd like to be clear about is what is the time period during which the complainant was not able to access the premises. So if it was not, so I understand from this clarification that setting that period as from October 2nd through January 11 would not be correct, would not be fair. I think I understood from Mr. Wilson that the end period there might be in November from his recent comments. Is anyone able to provide clarity as to when, early November, mid-November, the time frame during which the complainant was not able to access the premises?
I would ask that you ask your questions for Mr. Wilson to Mr. Wilson, and that we not have the investigator talk now and Ms. Ender talk now, because then it'll just be even more confusing.
Yes, I think I was addressing this question to Mr. Wilson.
Yes, thank you, Commissioner. My recollection is that it was within a week. The ramp was installed. They tried this block 2x4 as sort of a wedge, and the Buckleys let the Gravers know that it wasn't working. And so he actually hired, I believe it was actually Mr. Marr, that came out and installed another ramp on the exterior, and the Buckleys themselves installed a ramp on the interior to sort of solve the lip issue. And that has been the case since, I believe, within a week of the installation on October 23rd. So it was certainly early November that it was addressed. And that was certainly, and what had happened was the first report came out. I think we were sort of taken aback. We did not realize that there was still an ongoing issue, because we had believed that that was all fixed by those remedies. And it was our understanding, we had argued to Executive Director and Mix Thompson Crossman that we did not know that. We had, it's our understanding these were all taken care of. That's why we asked for there to be a brief reconsideration of that. And I believe that there was, and that it was resolved that had been addressed and it was satisfactory. And that was certainly early November that they addressed that.
Okay, so I've corrected my note of January 11 to on or about November 1st. Thank you, Mr. Wilson.
Thank you.
Okay, now we will turn to Ms. Ender. You also have about 5 minutes, Ms. Ender. Where are you? There you are. Okay, you are muted. Can you, Ms. Ender, I think you're still muted. Still muted.
There we go. Thank you. So I disagree that the issues were resolved at the beginning of November. I submitted, after the initial report, I submitted a series of photographs showing different stages. Now, I understood the issue of a lip of being related to the juncture between the metal ramp and the wooden pathway. And then the issue that I raised in this set of photographs of the ramp, once the metal ramp was attached to that pathway, was a barrier to get into the unit. And I do remember Mr. Wilson being quite upset about, what are we doing here? We're going to make you, we don't have an obligation to make the whole apartment accessible. So I continue to say that there was this barrier that existed after November 1st. And that, again, I don't know if it's resolved or not at this point. It probably is, but I don't know. I thought that was going to be the case earlier. So I'll just leave it that at the time of the report, that it had not been adequately resolved. The issue of how long it was is twofold. One is that it's not there should have been access, and there wasn't access. Access was lost. Independent access was lost and not assured at the time we wrote the complaint and at the time of the initial investigators report, which was then taken back to be updated. So in the update, I submitted the set of photographs showing that a barrier remained. Again, at some point, it may have been resolved, but I don't know that. The record was closed by the time we had the issue of whether there is access now or not. If it's an unreasonable delay, that would be one thing, but okay. If there's an unreasonable delay, that's discrimination. If there is a lack of, and I'm going to argue, I do argue that I'm sorry, I'm just twisting myself around in knots. I would have objected to a report that found that there was complete access. I would not necessarily have objected to a report that found that access had been resolved as of a certain date. And if that date had been beginning of November, that would have been up to the commission we would have had a different report. We would have had a different outcome of the report, possibly. So we had a report that said there was a denial of reasonable accommodation and that there was still an impediment. So I would have objected if there had been a position that the impediment had been resolved in a way. Because when we filed our complaint in good faith and without assurance that everything was going to be addressed. Even if the report had been, if the issue was resolved by the beginning of November, that would still have been a month. I'm sorry. There would still have been a period where it was unreasonable to have left Mr. Buckley without independent access to his home. So we filed the complaint October 1st. I don't know when it was resolved, when this impediment issue was resolved. I thought the lip issue was, like I said, the connection between the metal ramp and the wooden walkway, and then that there was another issue that had not been resolved that led to entry into the apartment because of this 2x4. And Mrs. Buckley had been describing some of the things that needed to happen. So I set a series of, I think, 6 photographs saying, this is fine, this is not, this is not, this is not, this is fine, this is not. And I think at the time that I submitted that, the issue of the link between the metal ramp and the wooden pathway had been resolved. And that would have been early November. but the issue of he still couldn't get into his apartment because of this, because the 2x4 issue hadn't been resolved. The pictures are very clear, and that was not resolved by early November.
Okay. Questions for Ms. Ender, Commissioner Whitworth?
No questions.
Mr. Wilson, you may not have 15 seconds. Commissioner Ashby,
None, thank you.
Commissioner David, Commissioner Dusant.
Ms. Zender, there was discussion. I'm trying to remember, I think it was you who brought it up, that a part of the rent for the premises before this last round was specifically for the inclusion of a ramp. Can you confirm that that's part of your client's presentation? And do you know any detail? Did you provide details about that in the record? I didn't see it.
Yes, it is in the record that when the Buckleys asked to move from a different street down to this unit, to this address on Tucker Street, that they did so specifically so that they could have a ramp. And that was several years ago. And at that point, Mr. Buckley could not navigate stairs. I understand Mr. Raver says he saw him navigate stairs, but
that's not what
the Buckleys
asking,
themselves have said he hasn't been able to navigate stairs at all for quite a few years. But so sometime after they moved to this new place, for a period of time before they got the ramp, and then for a period of time after they had lived there, he could not access there were just like 2 stairs, I think, or there were
sorry to interrupt you. That's not quite what I was asking. I thought I heard, I believe it was you, perhaps I misunderstood and it came from someone else, a matter that I don't recall reading in the record. So maybe, so I'm asking, someone said that part of the rent for the premises before this whole new ramp situation came, before the abatement issue, that there was rent for the premises, and there was a specific part of that rent that was for the ramp, for having the ramp. Did I misunderstand that? Did anybody else hear that?
I said, yeah, and I'll stand by this, is that they paid an extra $150 a month when they moved to this property because it had a ramp.
Oh.
Other people were paying $600 and they paid $750. And it was a very amicable relationship for a long time. So they were paying without any complaint $150 more than other tenants for this property were because of the ramp in that unit.
And that was for the duration of their occupancy of the unit.
Correct.
And the new rent at $900 a month does not include a payment for the ramp. It is the same rent as the other unit in the building.
Right. I mean, there's a different, I mean, there's a dispute about the rent, but that is not to do with this case.
Understood. I'm just trying to make sure I understand that there was a specific payment for the ramp. In this relationship prior to this dispute, the parties understood that a part of the payment the complainants were making to the respondents was specifically for the fact that there was a ramp included with the apartment. Thank you. Thank you. I think you've confirmed that. Thank you.
Okay, so we've heard from complainants and respondents, and now we're going to turn to the investigator.
Again.
Again.
Okay, let's see if I can clarify some things. My name is Kit Thompson-Crossman. I'm the investigator assigned to this case. The structural impediments really are secondary to the reason that I found reasonable grounds and that I'm making a recommendation of reasonable grounds in this case. So I'm going to refocus this a little bit for a moment on the period of time between when complainants moved back into the apartment after the lead abatement was finished and when the ramp got put back. So the record is pretty clear that respondents knew that Mr. Buckley needed the ramp. There's this whole thing about they asked to rent the apartment because of the ramp. There was the extra payment because of the ramp. There were conversations about Mr. Buckley needing the ramp. So Mr. Buckley needed the ramp before the lead abatement happened. Whether or not Mr. Buckley could navigate stairs is not really relevant to that. Respondents knew that Mr. Buckley needed the ramp to access the apartment. And that's why they wanted that apartment, because of the ramp. So just because it's a relatively short time frame, in this case, didn't lead me to think that there had not been discrimination. So the Buckleys, the lead abatement finishes about September 21st, 2020. The Buckleys are able to move back in at that point. There's no ramp, so Mr. Buckley can't move back in. It's true that the Grabers didn't know that he'd been in the hospital. They didn't know about the amputation, but they knew that he needed the ramp to access the apartment prior to him going to into the hospital. There's no indication that there was any conversation, that there was any intent on the part of the respondents to put the ramp back until after the complaint was filed. That again is a relatively short period of time, from September 21st-ish until we received the complaint on October 2nd, and then respondents received the complaint on October 7th. But still, there's no effort in that time to put the ramp back. So Mr. Buckley, regardless of whether he's actually living in the apartment or not, can't get in to the apartment because there's no ramp. The respondents know he needs a ramp. He can't get in because there isn't a ramp there. About the structural impediments after the ramp is put on, there's some evidence in the record that respondents didn't know, the respondents hadn't fixed the impediments until December 4th, that they knew as of December 4th there were structural impediments that hadn't been addressed. There's some evidence that then there's some conversation back and forth about stuff getting fixed. When I wrote the initial report, it seemed that the structural impediments were still there. I reopened the record, I got some more submissions, I closed the record, I then got another submission saying, hey, we're still in conversation about this, we thought it had been fixed. At that point, I was past my deadline with HUD. I already had made a finding, a recommendation that there are reasonable grounds based on the fact that there was no ramp between when the lead abatement finished and when the complaint was filed and the respondents were notified of it. So the issue about the structural impediments seemed secondary to me at that point. There were structural impediments. There also seemed to be, at some point starting late 2020, some good faith efforts on the part of respondents to address those. That's ongoing. It isn't really clear that anyone knows where that stands right now. And I'm not sure why that is, but my job is to conduct a preliminary investigation. And with the housing cases, I have a really tight timeline to do that. And so by the time I had closed the record again, I'd already blown my deadline with HUD and I needed to get the report out. We have this 50-50 standard for the reason that I'm tasked with doing a preliminary investigation. And that was what I had done at that point. This was a close case because of the short amount of time. But again, as we've discussed earlier today in other cases, we have this 50-50 standard. It seemed as likely to me, sorry, thanks, Amy. I will also say the baby is going through a sleep regression and I have had a lot of coffee. So if I'm talking real fast, please tell me to slow down. I've been awake since about 3. Anyway, so I'm happy to answer any questions that you have to the best of my ability, but that was what I was basing my recommendation on, is this time frame between when the lead abatement happened, when the respondents were notified of the complaint, and when the ramp got back on. That was what I was really focusing on. So I'm happy to take your questions.
Thank you, Kit. I had just messaged Kit to breathe. So I see you, Commissioner Doosan, but I'm going to go in order just because I do it every time. So Commissioner Whitworth, questions for the investigator?
No questions. Thanks, Kit.
Commissioner Ashby,
No, thank you.
Commissioner David,
No.
Commissioner Dusan.
Thank you. Ms. Thompson Crossman, looking at your interview notes on page 8, the top of the page, you relate that when Christopher went into the hospital, Mary spoke to Mr. Marr, who said he wouldn't have to rush to put the ramp back in, to which Mary agreed. However, her understanding was that they were going to put the ramp back, and that had not happened. When she later went to the apartment to pick up mail, the ramp hadn't been put back. So I just, that stood out to me. So it's your understanding, though, that there's no specific factual evidence that that conversation between Mary and Mr. Marr was relayed to the owners.
No, there is evidence in the record that I think Attorney Ender references that the complainants were used to seeing Mr. Graver around and didn't really after the lead abatement. So they hadn't had an opportunity to speak with him. And I don't have any evidence in the record that Mr. Marr relayed that conversation to him.
Thank you.
Commissioner Deuce, all set? Okay. Thank you, Kit. Rest your brain. So at this point, we've heard from the parties, we've heard from the investigator. I'm going to keep tendering my apologies for the super confusing proceedings, but we are at the point where we are ready for a motion or motions. And you could take it separately or together. There are 4 proposed findings.
I'll move that we accept all 4 findings of the investigator, that there are reasonable grounds to believe respondents discriminated against complainant on the basis of disability and conciliation should be attempted. Similarly, that the respondent discriminated against claimant's family, Mary and Mariah Buckley, on the basis of association with a person of disability and conciliation should be attempted in accordance with the act, but that there are no reasonable grounds to believe respondent retaliated against the complainant or his family for engaging in protected activity, and the claim should be dismissed, and that there are no reasonable grounds to believe that respondent Joshua Marr discriminated against or retaliated against the complainant. And this claim should be dismissed in accordance with the act.
Is
Second.
there? Okay. It's
In
moved and
support,
yeah.
in support of my motions, I agree this is a close case. From the totality of the evidence and from especially the interview summaries, I'm left with the belief that the respondent knew how important it was to have this ramp. That was very clear from the commencement of the tenancy, that any suggestion that the respondent had come to believe that the complainant no longer needed the ramp was something that's just not credible. And so any delay really is unacceptable after the removal of the ramp. But furthermore, I am finding, or I'm inclined to believe, certainly to the standard that complainant must meet in order to have a claim go forward, I'm inclined to believe that this ramp would never have been reinstalled unless the complainant had made her complaint. I might have ruled differently, with all due respect to Kit. I might have ruled differently on the agency issue. Actually, I think this is a case of inherent authority as opposed to apparent authority. The respondent is not responsible for what appears to be the authority of the agent, but there's inherent authority here. This family member working on this property, I would argue, has inherent authority to make decisions. And in fact, he did make representations that they were not going to put the ramp back on again. And it's disingenuous to suggest that because he was contracted to do a particular job, lead abatement, that his comments about his unwillingness to put the ramp back on again, it's disingenuous to say that that's not something you can attribute to the respondent. I think you can. he certainly didn't hesitate to talk about the fact that the property wasn't ADA compliant, and that's why a ramp didn't need to be put on. And furthermore, he did discuss with the complainant, and it doesn't seem to be rebutted, that in fact, there'd be no hurry to put the ramp back on. Well, if he said those words, it seemed that that he had the authority then to make those representations on behalf of the respondent, and he in fact did. So I might have come down differently on the agency relationship, but if we don't come down differently on that legal relationship, my recommendation is still the same, because I make an inference that the complainants learned from Mr. Marr that in fact the complainant was continuing to request a ramp. I just make that inference. I think it's disingenuous to say that the complainants didn't know. And I know Mr. Wilson has said that it's uncontested that they didn't know. I don't think I heard Ms. Ender say that they stipulated. I do say that I do see that the record doesn't make an express finding that the respondent knew of Mr. Marr's representations about the ramp, but I don't see that Ms. Ender or the complainant conceded that in fact that I'm not entitled to that inference. And so those are all the reasons why I make my recommendations.
I wholeheartedly agree with Commissioner Ashby. They knew or should have known, and I reject Mr. Wilson's assertion that technically there's no proof that they knew that the ramp was necessary. They took the apartment because of the ramp. They paid extra for the ramp. They knew he was in the hospital. They made themselves scarce because their son-in-law was doing the work, and because their daughter, they were in the process of transferring the ownership to their daughter. I fully believe that they knew exactly what was going on, and they had no intention of doing the ramp because they thought somebody else was going to pay for it. I decided to back away from what I was going to challenge the investigator on, that there's no retaliation here. They're raising that rent because of that having to make that expense. Had Patricia Ender said that Attorney Ender said that she was challenging that no reasonable grounds, I would have found that to be a close case. But I decided that I'm not going to go to the extent of trying to reverse that one finding when the complainant's not pursuing it. But clearly the first two, and the fact that Marr didn't initiate any discrimination, number 4, I think are all easily affirmable, and we'll vote for the motion.
Any additional discussion, Commissioner Dusan?
Yes, I just want to thank my fellow commissioners. They've referenced all of the factual pieces that were of concern to me, and that driven my choice to vote in favor of these motions. I think of particular concern is that the reasonable accommodation issue here, the requirement is to accommodate as necessary to give equal opportunity to use and enjoy the housing. And so providing a beautiful ramp whose lip still does not allow the person, the renter, to access the housing is, if you provide a ramp with a gap, that's a problem. If you provide a ramp with a lip, that's a problem. So I tack on the time, and I tried to use the most generous time frame for the time period during which the complainant could not access his home. But even one day is not short when you can't get into your home because of a disability that your landlord is aware of. So I just think it's clearly discrimination. I think it's an excellent report by the investigator. And I think at its base here, there's not vicious intent, but there is a failure to take seriously the importance that a usable ramp has to the tenant with a disability to get into his own home. So thank you.
So any additional discussion from commissioners? Seeing none. The motion is to adopt all 4 recommended findings. So 2 reasonable grounds, 2 no reasonable grounds. All those commissioners in favor, please raise your hand and say yes.
Yes.
The vote is 4-0. So there are 2 reasonable grounds against Mr. and Mrs. Graver, 1 no reasonable grounds against Mr. and Mrs. Graver, and 1 no reasonable grounds against Mr. Marr. The Commission will send a letter to the parties and council outlining the findings and the process to follow. And at this point, we have 1 case left. We did check the voicemail here. There's nothing from Ms. Smith. We haven't gotten an email from her. So I think she's been provided due process. Yep, I have no emails from her. We have no voicemail from her. So I think we can go ahead and call the case. Deb, yeah, do you want to do the honors? Deb, you're muted.
Would anybody like to make a motion, please, on the case of E19-0241 Lana Smith v. Custom Coach and Limousine, and Paul Graves, Mitchell, Hope, Simmons?
So it occurs to me I should have said, for commissioner's reference, generally speaking, I should have said this, when the party opposing the recommended decision does not appear, typically the commission's process is to make a motion to adopt the recommended decision. Yep, didn't say that. Should have said that before. Sorry.
And I'll move that we adopt the recommendation, find that there's no reasonable grounds to believe that unlawful discrimination occurred in E19-0241.
Jill, I think you said you seconded that?
Yes. Yes.
Okay.
Ma'am. Yes, Madam Director.
So there's a motion to adopt a no reasonable grounds finding in Smith versus Custom Coach et al. That's been seconded. Is there any discussion among commissioners? Seeing none. All those in favor of the motion, all those commissioners in favor of the motion, raise your hand and say yes.
Yes.
1, 2, 3, 4. Okay, the finding there is no reasonable grounds. So that takes care of our case agenda. And unless any commissioner wants to take a quick break, typically we would have a motion to, and I wasn't looking at my screen if anybody raised their hand. Typically, we would have a motion to go into executive session with someone willing to do the honors. That cites the statute. No one. Crickets.
I move we go into executive session
Wait,
pursuant to
there it is.
section 4056E.
Is there a second?
Second.
All those commissioners in favor of going into executive session for the reasons cited. 1, raise your hand. 1, 2, 3, 4. Okay, at this point, I am going to move the commissioners and council and me and our record keeper into executive session. Everyone else is free to remain here. This part of the meeting will stay open until we return. Theoretically, I'm going to move the commissioners and Barbara and Melody and me into the room for executive session. Here we go. Ed, did I not put you in the room? Oh, Ed, I forgot you. Hold on. Hold on. I forgot you, Ed. Hold on. How did I forget you? Ed, hold on. Don't go. Ed. Ed, I'm trying to put you in the room, but now I can't figure out how. Hold on. I'll come back for you. Hold on. I don't know why I can't put you in that room. Hold on. I'm not at my best today, Deb. I forgot to put Ed in there and then I couldn't add him. Nope, you're muted.
So are you putting us back in executive
Yeah.
session? Okay.
Please close out of executive session. Apparently, it is just not my day. Yeah, Barbara, sorry, I forgot Ed, and you can't add someone there afterwards.
But Ed was there.
Ed was there?
Yeah, you were the only one who wasn't there.
Oh my gosh, I'm so sorry. I thought I forgot Ed. But Ed was there, you say?
Ed was there, but now he's gone.
He should be coming back. Ed. Yeah, no, he's not on my list. Oh, Ed's in the waiting room. Okay. I did not put him in the waiting room. Ed, I'm sorry. I need to add you to the executive session list.
Yeah, it just went blank on me and then
Sorry.
no problem.
I'm trying to add you to the list for executive session. It's not my best day today, Ed, sorry.
Well, I went out and came back in through the link and it worked.
Okay.
So, to clarify, if this is executive session, we still have Ms. Ender.
It's not.
Oh.
This is not executive session.
Okay, all right.
Not executive session. You're back in the regular meeting and I'm trying to figure out how to add Ed to the executive session list. Because I'm going to try again and start over. Add a room.
Yeah, I think you're doing it. They add a new room and put everybody in it.
Yeah. Assign Barbara, Deb, Ed, Jeff, Jill, Mel. Okay. Trying again. I have everybody but Patricia. Here we go. Trying again. Great job. Everybody did it. Okay, so we have we need a motion not to litigate, to follow Commission Counsel's recommendations in the 3 cases that we can reference, and also motion to approve draft settlement offer in PA 180433 Schnitzer versus Dunkin' Donuts, and to authorize counsel to sign that on your behalf. Is that right? Okay. So they would generally be 2. What?
So move both motions.
Oh my gosh. Okay. Jeff made both motions in my mind. Is there a second? Deb is seconding both motions. Okay. Okay, Deb.
Sorry, I was on mute. Sorry.
You were. Okay, so I'm going to present these together. That's kosher, right, Barbara?
Wait, I just want to explain in great detail my reason for moving.
You're trying to change my mind?
All in favor.
Help me make up my mind.
In favor.
Yeah, you can take it all together. A motion to do what I say is always favored.
All right, everybody agrees with doing what Barbara says. It's her greatest dream come true right now. It's the moment she's been waiting for.
Fair point.
Okay. I think that's everything. I feel like I'm forgetting something, but I don't know what. Well, good job. Welcome, Jill. It's only going to get better from here.
Stop saying things like that.
That's true. I'm jinxing myself. And we'll see you all in April 12th. And I'm going to tentatively tack an hour on for a board discussion. Yes, Jill.
Someone will be in touch with me about switching to a different laptop or something? Okay.
Yes. We're going to format and get the laptop together for you so you don't have to use your own computer next time. Awesome. Anything else from folks?
No, thank you.
Thank you all so much for your patience and good humor. We'll see you in April.
Thank you.
Bye.
Nice to meet you, Jill.